Well,
Lordship, I am petitioning person. I have submitted an appeal challenging the compensation only.
they paid the 22,000 within that 3-month period, or they paid it with interest?
Without any interest and
They paid it within 3
no,
months.
no, they didn't pay anything because I had submitted an appeal in the state commission.
Now we have got 25,000 more.
25,000 more. Now, if they didn't pay the 22,000 within that 3 months, you'll also get interest on that.
But sir, I have sued the laptop, not.
You can't ask for what? You want now 30 lakhs
Sir,
for a 22,000 laptop that you bought.
sir, they had been adamant on not obeying any of the consumer protection law. They changed the nature of warranty, duration of the warranty.
You can't say that for a 22,000 laptop that you bought, you're entitled to 30 lakhs compensation.
Want to settle down in life with purchasing one defective laptop?
No, sir. Sir, these are MNCs.
You've got 25,000 extra once you went to the State Consumer Dispute Redressal Commission.
But sir, honorable.
And if they didn't pay you the 22,000.
No.
Are you sure?
Yeah, sure.
If they didn't pay, then they'll have to pay interest also on that. So you'll get some more amount there.
No, but sir, honorable National Commission said that okay, they can consider the matter to up to 1 lakh only, but they cannot give us few amount.
Sorry, we are not going to entertain this. We find no good ground and reason to interfere with the improved judgment, especially petitions accordingly dismissed.
So your lordships have dismissed connected other matters. There's
Same judge.
one aspect on compensation. On lapse, my lords, the position holds that the 2013 Act does not apply to the Karnataka Act. But importantly, on compensation, and this, my lords, would have some far-reaching effect. Page 147, the state of Karnataka amended the KIDB Act and provided, my lords, at the amended section 30 that compensation, my lords, would be payable under the 2013 Act.
Yes.
And please see the language of this amendment. Sections 23, etc., of the 2013 Act shall, for that purpose, be deemed to form part of this Act in the same manner as if they were reenacted in the body thereof. Now, therefore, my lords, yes,
This is already argued.
this, my lords, so this the High Court holds. This, just one moment, sir. This the High Court holds curiously at para 34 onwards as being inapplicable to us basis coordinate bench judgments which exclude 24. Now, I'm not on 24. The amendment also does not mention 24. But the benefit of compensation under the 2013 Act to land losers, which has been brought in by amendment, ought to be considered. And that the High Court holds at 34 onwards.
Yes.
By referring to two judgments clause in Ram Reddy and Anand Swami, both of which your lordship see pertain to the applicability of 24. 24, the position is settled by your lordship, Anusuya Bai. But the beneficial amendment that came in 22, the High Court lords could not have foreclosed that benefit to the land losers.
34 is past, which 34, page 30.
Yeah, lords, para 34, sorry.
Page,
Sorry. That is at page 98.
98.
Yes. This is the neat question, lords. As regards the fourth question,
Lord, may I? Yes.
whether the provisions of the 2013 Act are applicable to an acquisition under the KIDB Act prior to the amending Act of 22. From the reading of the judgments relied on either side, we notice that the legal proposition which arises as follows. A co-equal bench of this court in Ram Reddy at para 44 held as under. This is on 24. Then in Anand Swami's case at
That aspect is dealt with in para 38.
after holding this.
With regard to this notification of 2022.
Yes, my lords, but following
That aspect has
Your-
been dealt with, and we also looked into it when we argued
Your lordships may also have a look at para 37, my lord. Para 37, your lordships may have a look at.
this. I'm sorry, my friend. Notice is yet.
No, here on the same day, Manas, I need to point this out. Manas, on the same day,
this aspect has already.
this was not on the record of the
Listening
This
to
was
the-
argued
They
before.
did
quite-
I was there in the earlier.
But this has a far-reaching effect.
You were also there.
This reasoning.
Manas, they waited, Manas, they
That's
discussed
the
the
moment,
courtyard.
sir.
No, this is
This.
Your acquisition?
2004. Award is in 2018.
She's a relative of the other
Just a moment, sir. The lordship has put me a question on facts. 2018 is the award. And the 2013 Act has come. Otherwise, not this amendment, the deeming provision would have no effect whatsoever.
See, it's not even borrowing antecedent facts because if compensation is pegged on the date of the original notification, maybe 28 or something here. What is the?
Yes, section
28. Then how do you extend it? Then you have to open all KADP.
No, my lords,
That's
only such, my lords, where the award has not been passed.
We're already.
Now, if the award,
By the date
No,
of the
what was
amendment, the amendment is passed. 2018.
18, you are about
2022 is the date.
quite so, the question would be whether the award was passed prior or after the 2013 Act. If the award is
Sorry,
passed,
Council, we've already.
13 Act per se is no problem. The
No,
problem is the
no,
2022
no,
amendment.
special act, your lordships are asking me, may I just respond?
The extension or incorporation
Yes,
That has been dealt with also.
by citation and reference would have happened in 2022.
22, but deemed to be, my lords, part of this act as if it were reenacted. Therefore, it relates back.
But according to you, if it relates back, everything has to be reopened. Why would you be the only one who's entitled to that?
Only, which is why I said it has far-reaching application, lords.
Exactly, which means that every acquisition under this act is liable to be reopened.
So long as, my lords, the right to come.
So all awards after 2013, according to will have to be
That is
reopened.
the tenor of the state's.
Third round of litigation.
Otherwise, my lords, this language.
Really, because the language is a little tricky there, doesn't mean that you can have the advantage of
My
it.
lords,
Create this kind of.
your lordships have held deeming provisions
Sorry.
to have full force. In
We've
fact,
already dismissed this.
She's a related.
My lord, one other thing, my lord, which your lordships may kindly see is paragraph 37. Lord, kindly see paragraph 37 also, my lord.
Interfere with this interim judgment, interfere with the interim judgment. All the more so as the other specially petitions arising from the same judgment have already been dismissed. Especially petitions according to this.
the lordships gave the others 4 months to vacate, my lords. The
Same.
Would that question
spent 2 months now because for the same survey they have already filed undertaking for 4 months. So now only 2 months are
Yes, the
remaining. They want
petitioners-
extension.
Just add this, in case the petitioners undertake to vacate the land or the premises in question within a period of 2 months.
4 months, your lordship.
2 months.
It's like the-
Same survey they have
It's a
already filed an
dwelling
undertaking.
house.
This order was in March.
Yes.
So Milords,
You want that 2 months to be extended there.
they want 2 months to be extended.
4 more months it doesn't.
Put the
Period
question.
of 4 months from today, they shall not be evicted by resorting to force and coercion.
But this question kindly be kept.
No, my lords, it's
No.
concluded by the.
This is a very dangerous question to leave.
Lords, it's a beneficial amendment.
Let's see, if we were a deserving case comes, then we'll see.
Grateful to you. Grateful.
Please, Your Lordship. Lord, should the petitions were received from the ground of delay of 120 days, my lords. My lords,
Originally, for revision, there was no limitation. In
my
the,
lords, honestly, my lords, it's a very cumbersome process in the.
No, in the Consumer Protection Act, for appeals, limitation is prescribed. Revision 53 perhaps. 53 does not speak of any limitation for the purpose of the NCDRC exercising revisionary jurisdiction.
That is how, my lords, that we were asked to file the.
But you also file a non declare petition.
How-
So where are you getting
is
this
there
prescribed
any
limitation?
judgment laying down that there's 90 days or something?
Where do you get it? Are you importing Schedule 1 to the Limitation Act and saying this?
My lords, honestly, we were asked to file this limitation
So
application.
you blindly file it without.
Not clear otherwise, my lords. That is the whole difficulty, my lords. They don't even clear it.
Much though.
Like it.
Well, but the difficulty is that this is not one-off case, my lords. It's a pan-India, my lords. There are a lot of people who had taken these deep discount bonds.
Common sense.
And these, my lords, by virtue of the act, whose files is presently, my lords, challenged for this honorable court, my lords, the bonds were repudiated, my lords, and the amount was thereafter. This is not one-off case, my lords. So this will have an impact on all the other matters. especially when the virus.
You sent individual notices also in 2008,
Please, my lords,
including to this individual.
Please, my lords, to everybody. And in fact, it was published in the newspaper as well.
No, you also sent him an individual notice.
Please, my lords, we did send.
And then he comes in 2024, is it?
But it's unilateral, is it?
You
But we
realize
have
Comes in
Because-
2019.
because of the act.
Because of the act.
Because of the act. Now the virus of the act is challenged, and in fact, my lords, there are several petitions which are pending before the.
No, in a
Conflicts.
deserving case, we'll look at it. This matter is only 1 lakh in odd way.
My lords, similarly, my lords,
So
all
if-
the matters.
We'll say the issue is left open, question of law will be left open. If there's a substantial amount involved, then you can,
All matters, my lords, only amount is around maybe.
all of them will be 1 lakh, 1 lakh, 1 lakh.
My lords, 50,000 somewhere.
And they'll all add up to how much though?
My lords, it's a pan-India, my lords, bond which was circulated, my lords, that is the ramification.
For 1 lakh, you'll have to come here.
It's-
And you people don't charge less.
The difficulty is that this, had it been one-off case, I would not have pressed it at all, my lords. But this is not one-off case, my lords, because similar matters pending before the Honorable NCDRC, now this matter they'll be considering and they'll be dismissing
At
everything.
least this will teach you to file your cases within time.
Because my lords, in fact, my lords, those petitions, they were.
According to the NCTRC, there's a delay of 120 days. So 120 plus 120 or 90 plus 100.
90.
So there's substantial delay there.
My lords, but then, my lords, I want to submit that, my lords, this is from UP, one is from Chandigarh, one is from Ludhiana.
Delay here?
We have.
Delay condone. Here also delay. Refiling, but still delay. Delay condone. We find no good ground and reason to interfere with the interim judgment. The especially petitions according to.
Well, this will become a precedent for other matters which are
Well,
pending.
you are saying that all of them are on par.
Well-
50,000, 1 lakh. We are not going to drag these small.
No, but it is not one case, my lords, there are hundreds of cases, my lords.
Well, they can't have a representative. Each of them will have to come, is it not? Because each case will be independent.
But this will become a.
So some 50,000 we have to drag into the Supreme Court.
My lords, but this will have a ramifications of
Well,
the other matters.
File your revisions within time then. That's a valuable lesson that you pick up from this.
Let's at least, my lords may not, my lords may say that the question of law is open at least.
Nothing.
It's challenged, my lords.
Yeah, it's only on the issue of delay. So where's the question of law now? The NCDRC says you've not made out a just cause for the delay.
My lords,
And on that ground,
for the other matter which is.
so that issue we can't leave open. It depends on the facts, whether you make out a just explanation for the delay of Sorry, nothing.
Circumstance of this
Nothing,
case, my
nothing.
lords.
nothing else. 15.
My lord, the resolution plan has been approved in clear violation of the time limit provided under the law.
So many extensions are given, we keep quiet all.
Your lordship, may kindly
Now you
see
come after the
page
resolution plan.
208, the order, my lord, that will indicate.
Approved by no less than 97.36%.
250, kindly see, my lord, page 250, the order passed by the.
How many extensions?
No, that's what I'm saying, my lord. So how many-
Where, what were you doing all through?
No, I was, no, my lord, the final order.
After the 270 days, 270 days.
330, my lord.
330.
330, my lord.
330.
330 expired on 2nd of November.
Then 330.
Now, my lord, now.
After that, how
has
many
been approved.
extensions?
No, my lord, your lordship may kindly see, your lordships have laid out, only if it is in an advanced stage, my lord, it is permitted. Today, my lord, it is an infancy stage. Kindly see page 7, my lord.
You got more than the liquidation value now.
No, my lord, no,
that's
no, my lord, let me put it, my lord. I'm on a different point, my lord. Today, my lord, the error which is committed by the tribunal is that, my lord, they proceeded on the assumption I'm an operational creditor. I'm not an operational creditor. I'm a financial creditor, my lord. I'm sure from the.
That also you never challenged within time.
No, your lordship, may kindly see, my lord, page.
No, you've never challenged that within time.
I'm challenging it, my lord.
No, where?
No, my lord, before
With regard to your
the
status.
technical, my lord, I challenged it.
With regard to your status.
Where are you? Where you must raise that I'm.
Status I have raised. I'll show your lordship,
You
lord.
only raised extension, you have raised
Extension.
No, your lordship may kindly come to.
violation of 30 subsection 1,
The approval of the resolution.
approval of the plan, nothing
That's
for
all.
me.
There's nothing in this.
No, my lord, I just, your lordship may come to page 30, my lord. Ground F.
Not before us.
Before tribunal, I'll show you, my lord. Your lordship may kindly come to
You must raise
Page-
it and argue it, Mr.
244, my lord. Page 240. page 240 is the appeal ground, my lord. 242 is the relevant portion, my lord.
Before the NCL.
Yes, my lord.
What did you say?
Page 244. Facts of the case, but the first sentence is page 244. The appellant is an unsecured financial creditor. No, my lord, page 244.
Not just an assertion.
No, no, my lord,
Once you are treated as an operational
I'm
creditor,
not, my lord. Your lordship will see the next page. I'm
you're just building
page
up your
49.
case as
No,
you
my lord,
go
page
along.
49. In fact,
They,
I'm
they condone, we find no grounded reason to interfere with the impugned judgment.
Not only one
Civil
subject.
appeal is accordingly.
Even in the resolution plan, my lord, I'm treated as a financial creditor. Now, my lord, but when it came to the tribunal, my lord, by mistake, what happened, my lord, I tell you, lordship, my lord. There were two cases. One by an operational creditor, the other by a financial creditor. Unfortunately, my lord, the tribunal proceeded on the assumption that both are operational creditor. This is the distinction which the tribunal did not notice. Would your lordship kindly see page 49, my lord?
You filed your claim, the RP also admitted your claim as an operational creditor.
No, my lord, it is the other way. Page 49, my lord, I'll show you, your lordship. Page 49,
Your dues were 18 crores. Ultimately, you
No, my-
it was 60 lakhs because of the percentage for operational creditors. We saw the figures also, Mr. Ravi.
Correct, my lord, but there is a factual mistake. Would your lordship kindly see page 49? The resolution plan itself shows Riddhi Siddhi Group of my lord, page 49. It shows, my lord, I am a financial creditor. So the unsecured.
No, there may be another transaction. That is must
Separate
have been settled as a
transaction.
No, my lord, it's only this transaction.
180. No, 180.
There's only 72 lakhs here.
Yes, my lord, 72 lakhs.
Whereas your other claim is much more.
That is 18 crores settled at 60 lakhs.
So that is not an operational creditor.
In fact, Lord, they got mixed up with the facts, Lord. I'll tell you, Lord, Lord. Now, I'll tell you, Lord, what happened was there were two.
He's got two separate transactions.
Transaction. There happens. There is multiple transactions happen. Depending on the.
Same.
I'm sorry, Lord, I was only one transaction.
Civil appeal is dismissed. 16.
Arbitration award against me with
Reasonable opportunity given is the finding.
21% interest minutes. Three things can I indicate here. How the arbitration has worked in. 3 dates that the lordships have and what is my case. In November of 19...
Your ground was that you were not given a reasonable opportunity, which would have been a valid ground, but
Yes.
that is on facts found to be incorrect. Sufficient number of adjournments taken by you.
Can I substantiate that? Minutes?
Then
A claim is filed, a written statement is filed, an award comes. That's all that has happened here. Nothing else has happened. No marking of documents, no examination of witnesses in November 99.
that is not something.
So therefore, what is the error of the is to lordship will just keep in mind the
manner in which the arbitrator conducts the proceedings is that part of 30.
Milos, so therefore, whether his claim is proved at all, Milos, not whether.
That is again on merit.
The arbitrations they agree not to at least.
Yes, so there is no such agreement, Milos. There is no such.
Where do you say
So
that?
actually, the advocate didn't even appear because he sought an adjournment saying I have to go for treatment to Bangalore in nature care. I am not there. So the arbitrator put it for hearing and passed an award against us, Milos. Now please see what has been. Interest he has imposed. Now these three facts, your lordships. He is a subcontractor of me. Rice has to be supplied to Bangladesh.
We can't go into the merits of the matter and sit and appeal over it.
No, this is the absolutely wrong application of the contract. The lordship does have the
Sorry,
contract.
Mr. Gaur.
No, but please see the interest part of it. 21% is not even provided for under the Act. No, ultimately his interest with 21% a public corporation.
What does the High Court say about
High Court doesn't go into it. High Court and neither the High Court nor Section 34 Court goes into it. Because the lordships give 10%, lordships give 12%. I can understand a public sector corporation is told pay with 21% interest. 3 crores against 1 crore, 5 crores has to be paid.
Good interest.
Because we have taken
raised it.
We have raised it. Because we have raised.
What's the 34 ground?
Yes, just lordship may just see that. Just give me one. 34 petition is on the
Where is the interest portion you are challenging now and where is the ground?
Just one second. Give me one. The 34 petition is on record, print. 34 petition is not on record, but just below
this entire selective filing here.
I understand. Last
We
day,
have to draw perhaps
I
some
understand that, but
adverse inference from that.
But please see, 21% is contrary to the.
Unless you raised it, where is the question?
Plus that petition is not here, so I can't say that. The lordship may just pass it over. If I get it, I'll file it. No difficulty.
21% post award.
Post award.
34 and 37, both are not here?
Both I'll file. Both I'll file.
Sorry.
Petition filed under section 34 of the arbitration. in Conciliation Act.
37 is
grounds raised.
No, just one second. 34 is there. I'm so sorry.
34 is there?
Yes, just give me 1 second. Just 1 second. Page number 113. Just give me 1 second.
113 is perhaps your 37.
37 is there. Sorry.
34 is not.
But I'll file 34.
Filed under section 34. That is placed on the record by the next date of hearing. List on 28 July.
28. Great. Obliged to you.
Item number 17.
Yes, sir. Let's appeal under the stay act. My lord, please just let me give your lordship a basic and show your lordship how it went wrong. This goes totally rewrites the Supreme Court judgment.
I don't really. It up after the
Break.
in July. In July.
Very best.
Skim through the orders. Really read it. And
16.
Your lordship has been already opening.
this kind of volume, it's impossible to take up a matter.
That's right, the last page.
July. Rewritten the earlier judgment on which we succeeded.
It's partly a remand order also.
But anyway, your lordships will July.
Based on
First week, if possible, my lord, because it's a miscellaneous, very miscellaneous stage.
14 July.
I am very well.
Great.
Item number 18.
In the previous
Your
order,
judgment. And that will be the of the judgment. My brother is a Bhamari Devi or something.
I'm only on two issues, my lord. First,
secondly, on facts also, the finding is they
The
filed in
application was filed in
2003
2007.
and it was repeated in
2007.
2007 and it was repeated in 17.
may just make one submission, my lord. The award, my lord, is 8th of December 2006.
6.
The-
Application is 9th March 2007.
Which is beyond 90 days. It is not within 90
Manage
days.
the-
Not on that.
These are all matters you yourself have to seek out.
Not on
You have
that.
all the records of people. You have to go and give once somebody is increased.
But I'm not on that. My lord, at page 71, the Honorable High Court records the contention that there is collusion of anti-trading because till 2012 there is no notice in that application.
That they were called for the file, gave it to Mr. Adarsh Bhushan, I think, if I remember memory of counsel right. And he saw it and then he was satisfied that there is no anti-dating.
My lord, if you look,
Same answer.
71, Lord, the notice issued is in 2012.
Nothing.
Not in these kind of matters, poor things.
We find no good ground and reason to
Great.
serve with the improvement of. The specialty petitions are accordingly dismissed.
Right.
If you may please, my lords.
Yes.
My lords, in para 39, 38 and 39 of the improved judgment, the Honorable High Court has said that there is no admission of liability.
Is your daughter-in-law?
My lords will see, my lords, there are a lot of disputes, but my lords will just see.
So you're bringing your private disputes into this?
No, my lords.
Summary suit?
Ms. Bhandari, it's not only a tribal issue, it's a trying issue.
Is your daughter-in-law? Where is the question?
My lords will just see, my lords will just see two.
Unconditional leave is granted, so you take.
My lords will just see 206.
You now want to pin her to that 25% of the.
My lords, yes, my lords, because what she is trying to do now,
And
she is filing.
your mail of 18.3 has a giveaway in para 2. Normally, mails are not written like that, it's written in own volition. Page
She has
44.
written the email.
I know, she's claimed to have written the email, page 44.
No, my lords will just see page 100.
She said, I signed wherever my husband asked me to sign.
You read para 2 of that.
I see
Did
that,
anybody
my lords.
write in that? You read the para 2?
Since, my lords, since 16.4, we are staying separately and never met for any business transaction, nor any paper is signed by me.
He's herself writing, I have never met you, I have never had a transaction.
My lords,
He's covering up some other ground somewhere else.
my lords, my lords will just see 2 pages.
Not a case for.
Then my lords will, if my lords is pleased, if my lords is inclined to dismiss, my lords, what she has done is she has now filed a fresh written statement in the Bombay High Court where they have to decide whether to take it on record. What she has done in that written statement is she has effaced this admission. My lords, I have a copy of the written statement. She
I
has,
don't go into that.
my lords, but then she's changed its stand, my lords, and they'll say,
Whatever issue you want to take up there.
my lords will just say
Find
that
no
the
ground and reason to interfere with the impugned judgment, especially petitions according to dismissal.
Number 20.
But I'm being led by Mr. Ranjit Kumar. He's stuck in another court. I request for a Passover.
In this
That's,
case,
I'm
the
seeking a
statement-
Passover. Mr. Ranjit Kumar is on his legs.
It is item 20.
Yes.
My lord,
Lord, kindly pass it over for.
There is a password. This perhaps I will not hear this. It's my judgment. Oh, okay. So even if he's asking only for extension of time, it may not look proper for me to do it. So list before a bench in which one of us, the Kumar ji, is not a member. So he's just asking for extension.
My brother will know this.
Please, my notes.
Yes.
Thus in item number 22, there are 4 or 5 submissions. First is, my lords, the basic mandate or the prerequisite for invoking section 43. That is not fulfilled, which is, my lords, I show the pages also, which is that I should be a creditor in the first place. And I should have been made a payment in preference to other creditors in the queue under waterfall mechanism. So not a whisper as to what debt was owed to me. On the contrary, my lords, at a page in the forensic report, it says payments have been made for no specific reason. So that is A, my lords, not fulfilling the mandate of 43, and B, my complete non-application of mine. Second, my lords.
Your only ground was that these transactions were in the normal course of business, which you were not able to prove.
No, my lord. So, which is what the forensic report and the NCLT say. But that is completely wrong.
Right.
My lords, may kindly bear with me for 2 minutes, my lords. And the other 2 points, my lords, which are very important. The forensic report, my lords, page after page, para after para, itself says inconclusive, not determined, and so much so that it says seek professional help to determine whether this forensic report is right.
How is fraudulent preference found? Show the finding.
Yes, yes. My lords may have page 53, that is the appendix. Appendix, my lords, 1, page.
Not the section.
My lord.
On facts.
In that report,
In the
the
report.
forensic audit
Yes.
report, how does it pin you down?
So the report starts from page number 76, my lords.
Hmm.
The relevant parts, my lords.
Yes.
My lords may have page 86. Page 86, point number 2, my lords. Says we have not been able to verify the following constraint. The necessary details are not available. Then page 87, my lords. Disclaimers, that's very important, my lords. The report is based on.
We are asking you for the finding against you,
My lord,
not for what is in your favor.
My lords, we have page 91. Page 91 is where the finding is. My lords, have that?
Yes.
We noted that the company had given advances to directors. As explained to us, this was for incurring business expenditure. There are 2 accounts maintained in the books for the same, namely Nagraj advance account and Arun Kumar advance account. The debits in the account represent advances paid to the parties, and credits generally represent the expenditure incurred or amount paid back in some cases. An analysis of the said account for last 2 years, 2017 to 2019, is as follows. It is clear from the above that there is a significant increase in the balance with no corresponding increase in the expenditure claim. Amounts have been paid without any specific reason.
How do you explain this?
Well, also, the explanation which has been the same, my original position in the statement of objections as well, which is the forensic reports only considers the advance accounts and doesn't consider the loan account. If it considers the loan account as well, then it will come to the finding that more than what the company owed, what I owe to the company owes me more. So for that, my lords may please have.
Where did you raise the contention that there are these 2 loan accounts which need to be obtained?
Page 149. 149 is my objection, statement of objection to the section 43 application filed by the liquidator. This is where I explain in detail, my lords. Actually, from my lords, page 147, I correct myself. Para 9, page 147.
The forensic audit report in the table at page 8 under the column makes a noting. This is the noting my lords have just seen. At the time of the forensic audit report itself, it was sufficiently clarified to forensic auditor that there are not 2 accounts but 4 accounts. The forensic auditor conveniently ignored the remaining 2 accounts, Nagraj loan account and Arun Kumar loan account. 2 accounts have been ignored, which are also maintained in the books of the company and the extract of the ledger for the period from so and so of Nagraj.
You receive money from the company and then you give a loan to the company.
My lords, and the loan given to the company is in the sum.
And what are you doing with the amount which you receive?
For the general
expenditure is shown there.
No, my lords, that is a fallacious.
It's the same amount being given as a loan, and thereafter you get it.
That is being used for the general purposes of the company, my lords. And my lords may kindly see one paragraph, my lords.
Have you shown us the additional report of the forensic auditor?
There are 2 reports.
That is with regard to my lords. That is with regard to 11 lakh extra, which is with regard to appellant number 3.
Yes.
And therein also, my lords, after a year, just on the conduct of the auditor, after a year they find out, they say, we have missed out on this 11 lakhs. So what due diligence, what exercise they did in the first place, my lords, which is my whole case. And my lords may kindly see.
You come to page 198, parallel.
It is seen, my lords.
That's the NCLT order.
My lords. In respect of original forensic audit report as well as the additional forensic observations have been made by forensic auditors and the figures, there too were supported by the bank statements.
Bank statements.
Bank statements. And the respondent failed to dispute the bank statements.
Yes.
Basis which the audit report has been prepared.
So your stand now that in the reconciliation, the corporate debtor owes me more.
My
What
lords.
you are saying?
Yes,
So it can't be preferential because otherwise,
my lords.
why would they further owe me? Where is that brought out?
My lords, that is there in my statement of objection, which my lords have just seen. That they failed to consider. I'll just show it again. And while we are at para 11, my lords, my case was never that the bank statements are dubious. My case was always this: bank statements for advance accounts have been considered, wherein shows how much money company has paid to me.
So did you lodge a claim? Since it's corporate debtor owed you money.
My lords.
So what will happen? You would have lodged a claim.
My lords.
Did you lodge a claim?
I would have.
Did you lodge a claim?
I will have to seek instructions on that.
Yes.
I'm sure, my lords, we would have. I will have to seek instructions. Before that, my lords, allow me
You would have lodged a claim.
to show.
There's no mention.
No, my lords, maybe it is not there because maybe perhaps it wasn't in the.
So the easiest way to show is no audit preference. Where is the question of 43 lakhs being given to me? They owe me much more. So here is my 14.
I understand.
14.
My lords, may give me time.
Per day, contemporary
I understand. My lords, may give me time.
That is a more crucial aspect. Where is the question of you saying that you don't know
So
about it?
defense is that they owe you money.
My lords, but before that, my lords, kindly just have section 43. The basic ingredient of the section is not made up. Just please have section 43 for a minute, my lords.
Is it within the look back?
No, so my lords, I'm on this point. 43.2. It says a corporate debtor shall be deemed to have given a preference. It's page number 53 foot of the page, my lords. Preference, and this is important, my lords. There is a transfer of property for benefit of a creditor, surety, guarantor, or on account of antecedent financial debt, operational debt owed by the corporate debtor. So what is important is, my lords, that payment has been made in discharge of a debt that the company owes to me. Now, please keep this in mind and please have this finding of the forensic auditor, my lords. My lords, 92, page 92. Page 92, the finding of the auditor. My lords, have that? It is clear.
Yes.
It is clear from the above that there is a significant increase in balance, no corresponding increase in expenditure claim. Now, this is very important, man. Amounts have been paid without any specific reason. So, neither there is any inquiry undertaken, not a whisper as to what debt was owed. as to whether I am creditor or not. On the contrary, it says payments have been made for no specific reason, for discharge of no debt. So the basic ingredient of section 43(2) is missing, my lords. And with this, my lords, may also see the forensic report. My lords, may have page number 87, my lords, of the audit report.
There's no mention of these people filing.
Page 87.
87. Now, have page 87?
Yes.
The second paragraph. This report is based, must have that?
Yes.
Exclusively on the facts and circumstances described in the engagement of team for conducting forensic audit, and is given based on representation expressed or implied and based on our interpretation, which may differ to other person.
No, you stick to your objection that it's ordinary course of business. What will be placed to show that it is ordinary course of business, it is not a preferential payment.
And what did you do with the money? There's no expenditure.
I have further money to be received. Here is the claim I have contemporaneously lodged.
There's no mention of your filing a claim in the RPs.
So, my lords, if this is what is bothering my lords, may give me some time, a week's time. I'll see.
What's the point of your preparing on the legal position without going the factual background?
No, I filed an affidavit to this effect.
And you still don't have any proof of this transaction being in the normal course of business.
Ordinary course. What ordinary course of business?
Why would you receive such a huge amount when compared to the earlier year? For what reason is this huge amount given to you and you show no expenditure for it? So it's obviously to
even then
divert the funds of the company.
No, my lords, even then. So what is important, my lords, is if it is for diverting the funds of the company, company owes me more. Company owes me more.
For the petition, for the appellant at length, we find no good ground and reasons to interfere with the interim judgment. The appeal is accordingly dismissed.
Please, your lordship. Section 23 of the Consumer Protection Act. The surveyor has assessed, firstly, the fire was doubtful, and then the surveyor has assessed 46 lakhs and odd, my lord, in his report on stocks as well as the building. The NCDRC of their own has given 2 crores 40 lakh rupees, my lord.
Total amount 46 lakhs.
46 lakhs 97 9.
Make it 50 lakhs.
Yes, approximately.
Issue notice. Returnable on 23rd September. Subject to the appellant depositing a sum of rupees 50 lakh with the registry of this court within
6 weeks.
Within 6 weeks. There shall be stay of operation of the interim judgment. The amount so deposited shall be fixed deposit for the time. The amount so deposited shall be invested in a fixed deposit in any nationalized bank for a period period of 6 months with an auto renewal clause.
My lord, delay be concerned.
Delay con-
Highly pledge.
But this, my lord, it needs to be settled because Order 8, Rule 1, as it originally stood,
Claim is the nature of a separate suit.
true, that is a theoretical proposition, my lord.
That is a.
Let me just, my lord, explain why, my lord, this is an important question. Order 8, Rule 1, originally as it stood, did not have a penal clause. It didn't have a clause that if you did not, then it will stand forfeited. That penal clause, my lord, is inserted in Order 8, Rule 1 only by way of the schedule of the Commercial Courts Act. There was a separate.
6A3 has not been considered.
Exactly, my lord. So if it is a penal provision like that, forfeiture is involved, then, my lord, it is a different question of construction. You cannot just apply a theoretical principle.
As a legal proposition also, this needs to be
What is answered?
Madras High Court has taken a view.
Madras High Court has taken a view, but your lordships have not considered it. Your lordships have considered in the context of a counterclaim, counter statement, plain written statement, plain written statement.
There's a reference to another judgment
statement in this.
Right? Because there's one written statement, so
There is already one.
Actually, there is a concept of additional written statement in CPC. You know,
That's a separate one, my lord.
that is where the defendant files
Yes.
after the written statement.
That's it.
This should be called a written statement to counter claim.
counter.
You repeatedly call it the additional written statement.
But that is what it was called originally also in 6A3. Well, that other additional written statement is in 9, which says that you will not file anything further without the permission
for all the respondents.
No, I appear for one block, but
Only
there are
one.
direct answers.
Which respondents are you appearing for?
R6, the respondent.
R6. Issue notice, returnable loan.
The two courts have considered, Lord, respectfully, Lord, 6G has considered.
Since the consequences are drastic,
It's returnable loan.
if it is to be held to be mandatory, there must be an
15
express
September.
sanction. That is the law on construction of settlements.
Loan council appears on KBIT for respond number 6 and waits for the notice. Notice shall be made on all, service of notice shall be made on the other respondents by all modes including custody.
Will it stay off the suit in the meantime? They should not proceed with the
Stay of suit number is
440.
440 of 2024 is the current number.
stay of suit number
It was originally
44?
something 440 of 2024.
440 of 2024 on the file
This is the high, the original site of the
on the file of.
We'll file a counter within 3 weeks, Lord. This issue has to be settled, Lord. Like, your lordship may keep it for final disposal after service.
Sorry,
yes,
3 weeks to file counter.
we've given you a date, September 15.
Readings can be completed. They can.
Reading shall be completed in the meanwhile.
yes.
Is it a non-miscellaneous day? Then we can argue it from there.
15th September is perhaps Monday, Mr. Rai. You want a referring date, is it? Very well then. 16th September.
Great.
Yes, keep your.
Let be done.
Yeah.
This is against a demolition that was carried out.
Concurrent findings.
No, not concurrent. City Civil Court and.
High court dismissed, appeal dismissed.
No. This is an interim stage. At the interim stage.
Oh, where are we?
Which matter? Item 20.
Oh, sorry, I'm looking at the wrong.
I'm so sorry.
This is Gauri Court's order.
Yes, that.
Correct, Lord.
Now, Lord, may I just try this, since your lordship try to.
Cancer patients were being treated there, and you break down.
No, Lord. So now, please permit me to make 2 or 3 points, and then I'll never.
Answer one point.
Yes.
Did you offer the person 538 square feet?
No,
accommodation
now, just one.
before
Now,
you demolish this?
no, now, correct. Now, very important question. In the demolition order itself, now there are 2 ways in which these people are compensated, either by way of giving them temporary accommodation or money. In this case, 35,000 per month was offered. It's mentioned in the demolition order itself.
Did you give him the 444 notice? Because
This was not a final notice.
the earlier proceeding was in 23 October.
Correct.
After that,
Yes.
he serves you a notice saying he's moving the civil court in the afternoon.
Yes, correct.
And you go and demolish it.
No, my lord, my notice is of October 23.
My notice.
When the High Court asks your officials to appear, they don't.
My lord, on that aspect, I can't really say now.
The same high-handedness, the approach is the same.
My lord, as long as I can.
Dealing with the citizen or even with the court.
I understand what your lordship is saying, fully I understand. But please just permit me to make 2 points, and then whatever your lordship says, of course, make it. Now, the first thing is, his suit was mainly, the tenor of the suit is what? That I should get 1319 square feet, not 538 square feet. That is the tenor of the suit. In the demolition order itself, he's recorded, his own submission is recorded, that as long as you give me 1319, I will vacate immediately and you can demolish. It's recorded in the demolition order. His own here, it was a hearing. We gave him a hearing, my lord.
Then you never gave him a commitment. Even now, the order is only this much, that temporary accommodation is 1319. Entitlement is what is otherwise.
Correct. Now, but temporary accommodation can't be given by the corporation is the point I'm trying to make. No, it's never given by the corporation.
Temporary.
You need to, when you demolish this property like this.
Below the developer, in this, below the developer has to give it. The developer has already given him 35,000 a month on this. Now, Lord, also now please take costs, etc. Lord, in a case like that.
Costs, definitely. This is a. In fact, they should have imposed more.
No, that's your lordship's view. But I was just saying there's 2 points taken. His only case was 1319 in annexure, and he's not even challenged the annexure
Put to the cancel.
My lord, this was an illegal. Now that the matter is over, let me tell you, lordship, what I actually did. It is an illegal construction. He had 538, which over time he expanded to 1319. That is why the annexure 2 of
demolished only less than 538 or left 538?
No, we had to demolish the whole thing. Well, the demolition order says the whole thing. That's why I wanted to show the lordship that that's all he wanted. All right.
They're happy.
But would your lordship just give me one little indulgence? Since there's some time now, time has been given to give him temporary accommodation. Now to find temporary accommodation in these areas is very difficult. Please give me a couple of months at least for that.
No, not at this stage. Then he's not even before. Oh, someone is appearing.
No.
Sometime.
Blind man wants a
Time is extended.
And
I can give
the order by.
Let him give me.
No, he'll get what he had. 1300 or whatever, he'll get
whatever. Time is extended by 4 weeks.
Correct.
From today.
And just one other point out that this is an interim order, so whatever is held may not prejudice the suit if your lordship may consider. All right. Apply.
This is the concurrent finding.
Yes, may Your Honor. Whether the plaintiff ratified this honorable court with regard to 3 requirements.
Go ahead.
That's right. May Your Honor.
Can't just say I've been in possession, they're fine.
May Your Honor. Defendant admitted that, so they have given possession for cultivation. But my claim is that agreement to sale. One is possession accepted. Second one,
findings of fact.
1987.
Findings of fact.
2 points. Only 2 points. 1 point I can
lost for all the points.
That's right, Your Honor. That's why.
The only indulgence we will show you is condone the delay. 206.
Your Lordship, other 2 points only 10 that Your Lordship. Only 2 points. One about the possession they admitted in page number 46.
You may have been in possession, but it needs to be shown to be adverse.
Yes, Your Lordship.
Where?
Your Lordship, adverse is
one owner executes the agreement. The other man is not in the picture.
I haven't filed any application suit for a specific performance.
It has the tenor of a permissive possession also. And secondly, you have not pleaded the dates for next week.
That's right. I can see.
Then I condone. We find no good ground and reason to interfere with the interim judgment. Discussion with petition is this.
Please, balance. Issue pertains to construction of the common area between property A and
again, finding of fact, whether that courtyard,
finding of fact,
the nature of that courtyard, whether you need to give half, they need to give half, or whether the entire thing has to be given by them.
But still the construction cannot be permitted.
Purely questions of fact.
Page 5, para 9 of the High Court,
seem to have adequate.
Where High Court categorically observes that 100 square meters is actually common area. How can construction now be permitted on those 100 common area? My rights are prejudiced. How will I?
We can't decide this question.
High Court order at page 54 is fairly more clear.
My lords, the High Court order at para 9. For a minute.
Para 9.
Para 9, page 4. 4 lines from the top. After leave. What was kept in common was the courtyard in between. This is a factual finding given. What was kept in common was the courtyard in between CTS number 3A and 3B. The said recitals cannot be termed. So, as a matter of fact, the courtyard is common. Now, in 3A, most part of it, the map is annexed along with the I. If my lord looks at the map, 90% of the common area falls in 3A. The construction is being carried out in 3A. Later on, what the court says is that since my brother sold it to subsequent, purchaser, if that sale deed, there is no
trying to shift the common area to the
other side.
plot, whereas it is half here, half there is the.
No, my lords, the map. My lords, the map is annexed with the eye.
You are trying to.
There is no clarity there.
My lords, it's an official map. My lords, please take a look
The
at the
High
map.
Court in fact records that.
And
the
that
said
was-
recital cannot be torn out of context to mean
My lords,
that
because-
it has to come only from CTS number.
Because the subsequent sale deed between the purchaser and my brother does not talk about it. My lords, would please take a look at the map. Please. Just one document. My lord, the map.
Purely a question of fact.
My lords, I'm just highlighting that.
Sorry. You find no good ground in this.
My lords, then may I request this? Let it be observed that the construction, whatever is happening, is subject to the outcome of the suit and no equities shall be claimed. At least that part can be. Because tomorrow I do not want the trial.
will anyhow apply. There is question.
My lords, it's about claiming of the equity. At least
The
those
suit is pending, is it not?
Correct. So
whatever happens is already hit by that document.
So my lords,
Nothing
just
needs
the
to be
recording would help.
Nothing needs to be said.
Please, lords. Yeah, my lords, at least the final, the observations and exhibit cannot be.
Dismissal of the special leave petition
or even the
shall not be taken, and the observations made in the impugned order shall not be taken to be expressions of opinion on the merits of the matter, and it shall be open to the trial court to deal with the matter independently and on its own merits in accordance with law.
Greatly.
Please, Lords. This is an item 28, the limited issue for Lordship's consideration is because that a vital piece of evidence has been overlooked. Because there is the respondent number 1 was my retailer. Whereas the agreement or the proposal had 2 stipulations which was be considered by your Lordship. One was that I was to pay him a minimum guarantee of 1.72 lakhs. And the second was an obligation on him to maintain a minimum stock of 25 lakhs. Now, the trial court notes that these two are not related. There is nothing stipulated in the agreement that he would not be entitled to minimum guarantee in case he does not maintain the stocks. So, which is contrary to the evidence given by the managing partner of respondent number 1. If your Lordship may just see, page 159, para 6 and 7. He himself admits his understanding of the contract. Plus, if I can draw your Lordship's attention straight to page 160.
Yes.
Plus 4th line from the top, I have produced, I'm reading from there. I have produced the document to show that how many goods have been sold in the discount sale. It is not true to suggest that I have not produced any document. I know the difference between dead stock and whole stock. It is true to suggest that to claim monthly guarantee and other benefits from the company, we should have stock of minimum balance worth of 35 lakhs.
To claim the
He is asking
guarantee.
effective fees reimbursement as finding at 205 of the trial court.
Lordship.
This 44 lakhs. He produced bills, vouchers, which the customers have come and returned, all that.
Because there are 2 aspects of it. The one was the minimum guarantee.
17 lakhs worth goods.
One was the minimum guarantee for which he's been was allowed 24 lakhs. That his own understanding is also that it is related to him maintaining 25 lakh rupees stock at all times. And because there is only one pager proposal which ultimately became an agreement, which stipulates obligation of both parties. I say I'll give you minimum guarantee. He has to maintain a stock. This aspect is being completely overlooked.
No, the statement doesn't really help you because he's only saying that the monthly guarantee and other benefits we need to have the stock. But
because if I can then draw your Lordship's attention to the proposal which ultimately is
para 22 at page 205.
May I read minutes? Plaintiff has also produced copies of emails sent to defendants by intimating the supply of defective materials and non-payment of minimum guarantee and margin money on sales, and also requested to send authorized person to rectify defective materials, which are exhibits P80 to P20. On perusal of the same, it appears that the plaintiff has sent the email to defendant number 2 with images of defective material, damaged shoes and footwears. The plaintiff has also produced copies of claim forms given by the customers. Now, this is the other aspect. This is on defective goods. On that also, there is no evidence shown, no local commissioner appointed ever.
2 courts have held against you.
Because I am only on the limited aspect of minimum guarantee that he has been awarded, which amounts to 24 lakhs. Which there, so one pager agreement laws, which stipulates obligations for me and him. If I can only draw your lordship's attention to that for a minute, which is laws annexure P1, page 48. Because in these kind of contracts, these are not detailed contracts, because the proposal takes over. So this is what we have. The lordship will see para 3. You will be supplied, plus that may not be relevant. Para 5, at any given point of time, you have to keep a minimum stock of 25 lakhs in the store so as to ensure proper and wide display of our merchandise. Now that's an obligation for him. And 9 is what he's claiming. We would be assuring a minimum guarantee for the Bellary store. This would be 1.72 lakh. If your earnings from sales at the store is less than this amount, the remaining amount would be reimbursed by you to you by respondent number 2. If there is no obligation of 4 on him, because of clause 5 on him, then a retailer like him can just sit back and relax.
So he needs to keep 25 lakhs irrespective of whether your minimum guarantee is being sold or not.
Because minimum guarantee is an assurance I am giving to him that
if it's not getting sold, so what is the he holding on to this 25 lakh worth of stock?
Yes, the security of 25 lakhs will be deposited.
No.
That's the finding.
What is that 50 lakhs that he's asked for? Recovery of 50
There's
lakhs?
a finding that 25 lakhs is paid to you.
Because initially he paid 25 lakhs for the goods
What is
purchased.
Deposit, initial deposit.
Yes.
The initial.
That's it.
Nothing else.
You find no good ground and reason to interfere with the interim judgment, especially petitions of public proceedings.
Item number 29.
29.
Yes, Your Lordship, in this, the petitioner has purchased the land on 4/9/2019. And after filing the application for demarcation, he
This
gets.
land was acquired in 1975-76.
Yes, Your Lordship, but
Then-
after he filed the application for
Then how
demarcation.
do you buy this acquired land and then say that a road is passing through? Obviously, it will pass through. It's already acquired.
Yes, Your
And
Lordship.
now you want compensation. They say that they already paid compensation.
Your seller has taken the money,
Your Lordship, they have.
sold the acquired land to you, part of it.
Yes, Your Lordship, but they have not filed any relevant.
Where will they have? Really, because they don't have any proper record, doesn't mean that they've not paid. Why would he have kept quiet? And you don't buy it from him. The LRs have sold it to you. So they've taken you for a ride. Whatever rights you have against them. The government doesn't have to compensate you. Sorry. We find no good ground and reason to interfere with the interim judgment, especially petitions accordingly dismissed.
Without considering my interim prayer for the.
Your interim prayer was already considered and an interim order is granted to you.
Which was.
Learned judge has moved on and become the Chief Justice of India
That's
also.
correct. So, Manoj, what
If
is
that order is not acted upon,
yes.
is your remedy asking for another interim order after how many years? 2013
Plus, I'll tell
revision.
you what has happened.
You don't even file a fresh IA.
Plus, that IA was not filed afresh,
Then
but I was.
you already have an interim order.
That's
Then
true.
there is a question of
That
granting
order was
another interim
filed by
order.
the authority, my lords.
Then you file a contempt proceeding.
Well, that order was, nothing was given to me in that.
Where is the question? This is just an admit order in a 2013.
I had an interim prayer in that. I've still been out despite the order. Well, that's a point in my
You
favor.
have an interim order, you keep quiet about it, and that's.
Well, that's a point in my favor that the interim order has not been implemented. Surely that can't be used against me, Malal,
That
because
is the question. You get an interim order, you do nothing about it. It's a 2013 writ petition, which is admitted now by way of the
it
interim
will come
order.
after 12
You
years.
say you have not given me.
May I say
interim
one, may I make one request? I'd like to what's falling from the board. May I make one? Your lordships just make, well, 12 years, after 12 years, the lordship leave has been granted. It will take another 12 years for it to come. Your
No,
lordships
why
may
will it
request
take
the High
another
Court.
12?
Because it does take Bombay High Court after leave granted, it doesn't come in less than 10 years. May I just make one request? Your lordships will consider requesting the High Court to decide it expeditiously, my man.
Move an application. Now the date is also
So
given.
let's record my record my statement that I'm making that, and with that liberty, I'm withdrawing the petition. Kindly just allow me that much. I'm making that request. Kindly record that, and with that liberty, I'm withdrawing the petition.
We find no good ground and reason to interfere with the interim judgment. However, we leave it open to the petitioners to seek early disposal of their case by filing an appropriate application before the High Court. In the event any such application is filed, the same may be considered expeditiously.
I'm late.
Especially petitions for the areas. Subject to the above observation, especially petitions.
I'm great.
But I pay for the. But my grievance here, my lord, is that the trial court holds, my lord, the execution petition as not maintained. But my submission is that there is a decree, which is a compromise decree, which will not efface.
As per which you never made the payment.
But I have not made the payment. But I'm saying that the decree will not efface itself.
That's why the High Court said you're entitled to 50%.
No, my lord, but that
refund as.
Kindly see now. No, I am now willing to pay the money, my lord. There was litigation between the parties. There was litigation between the parties, my lord. And please see, my lord, clause. Please see the clause, my lord, at page 40, clause 7, which is referred to.
Page 40.
40.
Of the supplementary.
Yes, my lord. No, this is the compromise.
The compromise.
This is the compromise decree. So the plaintiff and defendant agrees and admits that in the event of non-compliance of the terms of the compromise, application and the supplementary agreement of the sale development agreement and cancellation of this sale deed referred to, the defendant shall refund half of the total amount received. Now, my lord, the cancellation never happened. Your lordship will see. Lord, there is, my lord, non-compliance. I'm glad I can't say anything. But cancellation of this never happened.
Now, something is pending still.
No, my lord, there is another appeal, my lord, that which is also decreed. The other purchase.
How much you have paid, Mr. Malay?
Lord, I have paid, my lord,
only 5 lakhs. 5 lakhs
You
you got
paid 50%.
No, Lord, after that I paid 20 lakhs, my lord.
In that 1 crore 30 thing.
Yes.
So you paid totally how much?
25.
So you now get 12.
12 and a half. Lord, the suit is decreed.
The second fellow.
Second purchase of lot and it is decreed, my lord, at a higher price, at 4 crores. Lord, at least the equity of my lord, money, my lord.
You don't abide by the compromise decree having invited it.
Therefore, I'm making a technical submission, my lord, that a decree, Lord, this is, I have not gone for specific performance.
It's on the issue limited notice on the question as of the quantum of refund payable to the petitioner.
If he has sold it to the other fellow.
No, and it is decreed for 4 crores.
He may be in a more magnanimous mood, so let us see.
We had other case when we ordered refund of earnest money, the council was anxious to immediately do it. And he has mentioned twice to get the money released.
List on issue notice return below September 15.
Just wanted a clarification. This is already a we wanted a clarification of your lordship.
So, I'm raising a preliminary objection about
104 plus your lordship's order.
The entire issue turns on that. That suit only. There is a question of you saying that suit has to be removed.
Like the ABS files on the ground that the authorities are confused. There can be a ground.
Look, that's not the.
And after more than
that, safety itself is subjected to challenge.
No, I don't understand why this act like. My clarification is not that suit should be removed. Your lordships noted while passing this order that there is a 2001 mutation in my favor after 19 years of revision is passed against that order. Your lordships extracted that mutation order in my favor at page 105 in your lordships. What was supposed to be done was to maintain this as the revenue entry. Now, what has now happened? Let's.
Order miscellaneous.
If I know.
Sorry.
May I withdraw this application? I'll withdraw this application.
None comes. Seeks permission to withdraw this miscellaneous application. Miscellaneous application recording dismissed as withdrawn.
Great.
Item number 33.
Please, your lordship.
The question of pre-deposit is actually taken up at the stage of section 11, specifically by the respondents. They choose to abandon that particular clause in the agreement. May kindly have clause 25 at page D. This is a pre-reference stage. May I read that clause?
Yeah.
It is also a term of this arbitration agreement that where the party invoking the arbitration is the contractor, no reference for arbitration shall be maintained unless the contractor furnishes to the full satisfaction of the executive engineer in charge of the work a security deposit of a sum determined according to the details given below, and a sum so deposited shall, on the termination of the arbitration proceedings, be adjusted against the cost, if any, awarded by the arbitrator against the claimant party, and the balance remaining after such adjustment, in the absence of any such cost being awarded, the whole of the sum will be refunded to him within 1 month from the date of the award.
Where do you get it?
Whereas this objection is taken by them at the stage of section 11, which is at page 32.
32.
Yes, para 3 months. The objection taken by the respondents as such that the security amount has to be made as per clause 25A7 of the agreement. Since the objection as such is formal in nature,
it's not given up.
But however,
It's left open for the
but it can't. This is a pre-reference. Please see the clause. Can you see the clause? The clause is a pre-reference clause. It is not a post-reference clause. Post-reference.
The High Court left it open.
They did not. It did not leave it open.
That is how this paragraph reads.
But let's just respectfully. In case under 16, how does it fall under section 16?
16.
That's here. The arbitrator has been appointed.
Counsel.
The
also dealt with this section 31, 31A.
It doesn't. In fact,
the arbitrator specifically deals with it. He refers to a judgment also.
In fact, Lombardi also doesn't deal with it. 31A is not dealt by Lombardi at all.
Sorry. We find no good ground and reason to interfere with the improved order, especially petitions according to this.
Item number 34.
Great thing. Applicant. There's a certain regulation under the CRP regulation, which is 39(1)BB. As to when
arguments heard, judgment reserved.
Yes, I'm unfortunately I am the promoter as well as the resolution.
So you already know what the judgment is going to say. So in anticipation of a negative judgment, you've come, is it?
Most respectfully,
how can you maintain
in the first hearing
an appeal against a judgment reserved order?
Just permit me to say this. Here is a situation, where I'm an MSME. I place my plan.
We're not on the merits. How do you maintain an appeal against a judgment reserved order?
It was a statutory appeal, which I had placed. I had filed before
the tribunal cannot
reserve hearing. In the first hearing,
is there a bar against reserving judgment on the first hearing?
My predicament is
then what is the grievance that you can canvass in this appeal?
The appeal, the order gets passed. The entire CRP will come to a close. My competitor
find no ground and reason to interfere with the interim judgment.
Yes.
The civil appeal is according to
they are on vacation. I'll withdraw it.
This trial and error practice here also is not a healthy practice. Try your luck, then withdraw.
There's no good. I don't want it to be. Here is situation.
Well, you tried your luck, now it's dismissed. So let's give it
to withdraw it.
And then, having argued for some time, then counsel for the FNF seeks permission to withdraw the appeal. Permission granted. The civil appeal is according to dismissed as well.
Grateful.
Item number 35.
35. I'm conscious of the fact.
Same. No interim order. Hearing is on 18th August. So this is much away 18th August.
Can I?
You asked for a hearing.
Lordship filed in 2017. On that day, I was bound to pay 10 rupees.
Challenging provisions of a statute, though. Your prayer in that question.
Consequent resolution passed. Lord, all that I want, if the Lordship will kindly bear with me.
You don't want that hike in the.
No, not even that. Lordship next hike will come on 1/1/26. Before that, the
Now you have a date, Mr. Basu.
Milord, right?
18th August.
Please see this, Milord. Kindly see this, Milord. Kindly see this.
Now that the date has been given,
See,
you
I
can
will
ask the High Court.
I've never been wanting any date, Milord. Your Lordship may kindly look at it. Dates are being given, it's not being taken up.
That is hardly a reason for us to interfere with the
No,
denial of interim.
No, I'm conscious of the fact that they cannot fix their board. No,
You asked
Your
for the matter to be taken.
it never reaches, that's why I humbly.
When your IA was heard, a date is given.
No, no,
You can't say that the matter never reaches.
Your Lordship, see, I came here twice, the same request is not coming, Milord. I will be happy.
You can use your persuasive skills before the High Court on 18th.
No, that's not working, that's the problem, Milord. Your Lordship, please bear with me.
We cannot have such a confession from you, Mr. Basu,
Kindly bear with me.
that your persuasive skills are not working.
No, just one minute, Lordship. It's not reaching. To have the persuasive skill, it must reach. Your
You
Lordship,
can make a mention and ask for it.
it's not being taken up.
We find no good ground and reason to interfere with the impugned judgment, as the High Court has already fixed 18/8/2025 as the date for the hearing of the main writ petition of the year 2017. The petitioner may
We request the High Court, if your Lordship are pleased.
we request the High Court to take up the writ petition on the date fixed,
And the High Court,
subject to just
and it-
exceptions.
request to the High Court to finish it.
No,
No, your Lordship,
we already said request.
17 onwards, you've been waiting. No, your Lordship.
We already said request, subject to just exceptions.
As expeditiously as possible, something that will work. Twice I've come to this court, the third time I'm coming here.
Don't mention the date or prefix, take up the writ petition expeditiously and dispose of this.
Thankful to the court. I know the difficulty in the request, but then something, the client is also 17 onwards, he's waiting. Thrice he came here. The court directed that it be taken up expeditiously. Now I thought the time limit ought to have been, which I live with. Thank you.
This had two how-
circumstances are largely confined to section 493. So, Lordship, this is not a dowry-related allegation of cruelty or treatment. The case started with a specific instance of.
Very well, we'll issue notice. Anyhow, you've been granted exemption from surrender. Issue notice.
Exemption has already been granted.
498A is not confined to dowry.
Yes, it is not confined to dowry.
Return to law.
Second part is there.
Second part is there, but I have some sufficient on this point. And
The written order granting exemption from surrendering shall stand extended.
Your Lordship.
Next date.
Your Lordship. Yeah. Lordship.
The court is.
Anyhow, there's a connected matter.
Yes, same order, lots, 28.
Issue notice.
Is listed.
Tag along with. Tag with.
7245. 7245.
Repeat criminal number 7245 of 2025.
Lord, can I, in addition, will not take Lord service through standing counsel?
Service shall be effected by all modes including custody. Permission is also granted to serve the learned standing counsel, standing or public nominated counsel for the state of Haryana.
Lord, it's listed on 20th of August.
No, we said tag. So we can-
Great.
This raises, my lord, a very important question.
High Court has granted leave.
High Court has granted. That's 134(1)(c).
Though it's not binding, but since it is.
No, I know. It's, I know this. Lord, but then it raises.
This.
My lord, there was, my lord, a stay of trial.
From 2014 it is.
Sorry,
9th September. There shall be stay of the trial in.
That is page 229 is the prayer.
20.
229.
229.
229, will not exact to stay further proceeding.
PDF 253.
Stay further.
What am I looking at now? I'm looking at all the wrong files. One moment.
There is some delay maybe, but it's an appeal.
Delay is coming. Delay
229.
Yeah.
229.
Yeah. The Quit India movement will not be, is continuing that 1930.
Stay further proceedings in CC number 125/PW/2006 on the file of the learned Metropolitan Magistrate Kurla, Mumbai, arising out of FIR number 313 of 2005.
That is one, the FIR and charge sheet I saw there.
It is connected to 9381.
And we changed them because in translation there is an error.
Permission is granted to file corrected proceedings
of the FIR and charge sheet.
In relation to the FIR and the charge sheet.
Yes.
Corrected documents.
It is connected to 9381 of 2024, my lords.
Yes.
That's well, the notice will have to be issued and to be tagged along with it, my lord. Well, there is a delay of 97 days.
Yes.
That
Delay
may be continued.
issue notice returnable on. When is the next date in these matters?
So that is 9381 of 2024. It's to be tagged along with that, my lord. Now the date
But
is
that
not
date seems to have passed. 9381 was supposed to have come up
on 6th of March, my lord. Then
on
thereafter it
20th
has
of
not.
January 2025. Next
Yes,
date has
my lord.
been given.
No, my lords, it is
When
not given.
say issue notice returnable on 23rd September, tagged with petition for special leave to appeal criminal number 9381 of 2024.
Lordship.
40 is deleted.
40 is deleted.
Some letters there. You're not told about. Raising for adjournment.
56 is deleted.
40 is also deleted. There's a letter. I was told that it's deleted also. There's a letter also for adjournment. 40, anyone is appearing?
My lords, an adjournment letter was filed seeking adjournment on personal health grounds, my lords.
Adjourn as per, in the light of the letter dated, there is no date on this page. The light of the letter, no, sorry. Letter for adjournment has been filed. List on 8 September.
No 41.
Lord, in 41, we had circulated a letter, my lord, for an adjustment.
41, there was no. You want an adjournment?
Because my senior is unavailable due to personal reasons.
We
had asked for a
counsel. At the request of learned counsel appearing for the petitioners, not his adjourned. List on 16th September.
Obliged.
No 42.
May I please?
Yes.
Brother, all witnesses turned hostile. So far as FIR is concerned, it is having only corroborative value. So far as what
recovery. Sickle is recovered at your instance. The murder weapon.
Mere recovery of weapon.
And you were there in the room with her.
Nobody says that. Nobody says. Even further, there is no evidence. There should be something to show that I am occupying a particular place and the occurrence took place at a particular time.
What time was this incident?
Even for that, there is no evidence.
When was the body found then?
Body found on a daytime. On a daytime.
At what time?
But at what time the occurrence took place?
At what time was the body found? As per the FIR. You're not giving us any answers, Mr. Sirajuddin.
Well, the thing is, we have got only these two judgments. Before that, I should say.
No documents are there.
We have through legal admission, we have got only this.
Take time to file all.
Yes.
File the deposition.
We have got some, recently we have got only Hindi versions, but we have sometime already, yes, yes.
Compile and file the relevant documents. List on How much time will you require?
The vacation we are strict almost 2 months, my lord.
Based on 16 September.
But
May it please your lordship. Your lordship, I am here on behalf of the petitioner who is the complainant. His daughter was found dead in
This
2013.
notice is issued though.
Your lordship,
Notice is issued and the matter is adjourned. We can understand your anguish, but against a notice order, how can we
your
interpret?
lordship, I am here on a very limited basis. The notice was issued 1 year back.
Hmm.
Even if the matter was adjourned, they've not even filed a status report, they've not even filed a reply, nothing has moved, your lordship.
In Punjab and Haryana, 6 lakh or more.
I'm not aware, your lordship, but the problem is the state hasn't even so much as filed a reply or a.
They only indicate that the matter needs to be taken up expeditiously, but beyond
Your
that.
lordship will consider issuing notice so that the state at least here is duty bound to file a report.
Probably the last adjournment is 10th of March 25.
Yes, your lordship, file adjournment, that's the issuance of the notice.
Wait to get that, we will put up on those.
Just allow me to issue notice and allow me to serve the standing counsel. Let
We
them
can't
file a report.
entertain a special petition.
Your lordship may then at least consider passing an order of limited time hearing, your lordship, 6 months disposal at least.
We are not inclined to entertain this petition, sorry, the special petition filed against notice of motion order in notice of motion order. However, keeping in mind the anguish that the petitioner would be facing as the father of the, as a father, we would request the High Court to give priority to the matter, and here we say expeditiously.
Your lordship may consider giving a time bound expeditious disposal.
We can't give a time frame for the High Court.
High Court is, we don't have a
Your lordship has been
Yeah.
debating arrest since 2022.
Expeditiously is as far as we go.
Grateful, your lordship.
Yeah, please, Lord. Because after 1 month of the complaint.
Cross allegations, cross FIRs.
No, Manoj,
You want the FIR
against
against?
cross FIR, Manoj.
Then
Only a 156(3) is filed. That is also an
whatever it is,
afterthought.
they're cross allegations now.
Manoj, that is an afterthought.
So
Because charge sheet is filed in
you
that.
want the FIR against you to be quashed. So your complaint against the others also will quash then.
No, Manoj, I am saying only.
That is the reason why the High Court.
Manoj,
said
charge sheet is
they
filed
looked
against
into it.
Kumar
It's
in
not a
that
case-
matter, Manoj. Manoj,
Not a case for quashing, cross allegations are there.
No, Manoj, I'm only saying, Manoj, this is an afterthought. Because once the charge sheet is filed, then he comes up with this kind of allegation saying, oh,
And
that
not
is some.
Brown and reason to interfere with the improvement of the special petitions dispute.
Grateful.
45.
Where is the evidence of the prosecutor brings?
Not
We have to go to the High Court to get the judgment.
But my lord, I will annex it, my lord. Once
You
just
got your
one-
father's evidence, but not the prosecutor.
I will annex.
You are raising the issue of the victim, is it?
Please.
She's supposed to have been 12 years old when
Yes.
you took her away.
Almost 11 years old. My lord, one page, page 45, doctor's report.
10 years and 11 months, yes.
Page 45, doctor's report.
11
Just
years.
one page, my lord. But I will annex, my lord.
Next, you produce that evidence.
Please, I will.
The deposition of the victim shall be placed on record by the next date of hearing. Let's go. How much time would you require?
4 weeks.
18th August. 46. I think this needs to be the same. Notice. You should like this.
Delay is there.
Delay control, issue notice, returnable on
Maybe a fixed date.
12th August. Service of note, service shall be made by all modes, including this.
47. Yes. Because in this case, I have already undergone almost 18 years and a half. So it's a fit case for remission allowance.
On merits, my lord, my name was not there in the FIR. On 161 CR.
Body is recovered at your instance. The child's body, burnt body from, where is it recovered from? Some forest?
Open space, open
No,
space.
but buried.
Buried, open space. my lord.
Legally, 2013 judgment, legally.
Very well,
One or two
consider,
more.
though.
We'll consider.
Issue notice on the delay as well as on the special leave petition. Returnable on 13th August.
Most of
Not 13th, 12th August.
Just because the magistrate doesn't have power to review his own judgment, we have 73 onwards.
One of the accused was also arrested.
Please note, in 74 minutes, it says.
On 22nd January, he seems to have made a mistake. You may be right in saying that it doesn't squarely fall within 362.
But then signing the orders in a.
But on facts, should we interfere?
No, in facts, it's a purely civil dispute.
Whereas Justice Sethi's judgment, RP Sethi's judgment,
Listen.
362, review may not be there. But if there is some magistrate issued, notice to the summons to President of India. All that can be, yes, now clearly see that order is 75. Page 75.
Please note. Before
He's
that,
obviously made a mistake.
before that,
I said that he's accepting
Latch
the
on to a technical.
73 and 74 also.
on facts. We are not inclined to
No,
interfere with the
Allow me a minute. Allow me.
legal proposition we have with you. This is perhaps stretching 362 beyond.
It's not. It's a purely civil dispute. The land is still with me. In fact, I was
One co-accused is also arrested.
arrested.
So
I
that
was done.
not a case.
May I just see 70?
On facts, we are not inclined to interfere with the impugned judgment, especially lay petitions accordingly dismissed. We are not on the legal issue.
It's a legal matter, so therefore there's a delay of 210 days.
Delay is not.
That's just kindly see page 7.
Your brother gives
The High Court relies on the witnesses who is not supported. My lord,
PW2.
not supported, my lord. Kindly, may I only show 2 pages? Page 23, my lord, kindly see. Page 23 is
He's
PW1.
lost one brother, maybe now he doesn't want to lose the other
My
brother.
lord, page 23, your lordship, may kindly see. PW1, the sister-in-law.
Let us see what PW2.
Yeah, both, my lord. May I just show PW1 for a minute, my lord? Page 23 first. Para 1, 4th line, my lord. Well, she came back from school, she says, and about 5th line from the top, it's in the chief examination itself. No one from the house was near the body, but people from neighborhood were present. So therefore, the entire story of prosecution is contradicted here only. Then she goes on to say that there was no one in the house, and she also says that there was no quarrel, etc. Then, my lord, so kindly see the next page 25 is PW2, and
This
page
is PW1 is your own wife, is it?
no, sister-in-law. So PW2's wife, my lord.
No.
And page 25 is PW2. My lord, may kindly see at page 26 the cross-examination. Para 4, my lord. It is true that when I reached home, I had not spoken to Hari. It is true that I had not met Hari. It is true that I had not filed any report at the police station. The police picked me up from my house, and wherever they asked me to sign in the police station, I signed it. But I said they only rely on PW10, who is the IEO, my lord, to say that the FIR is true. But there is no recovery.
His cross-examination, what does he say?
That's what page 4. That's from para 4, my lord, page 26 is what I was reading. At page 26, it is true that when I reached home, I had not spoken to Hari. It is true that I had not met Hari. It is true that I had not filed any report to the police station. The police picked me up from my house, and wherever they asked me to sign in the police station, I signed because of the fear of the police. It is true that Harilal did not tell anything to anyone in the police station or at home in my presence. We are 5 brothers, 2 of them have died, 3 of us live together, etc. With love and affection, without any animosity. Harilal and Rohit live next to me in a separate room. There is no eyewitness, my lord. The recovery of stone is not proved. The punch witnesses have turned hostile. Not even a single witness has supported the prosecution now.
You used to be in the same room with the deceased.
Yes, but there is no last scene here, my lord. There is no allegation that I was last seen.
What time is the body?
11 a.m. in the morning, 11:30 a.m. in the morning. And PW1 and 2 is what the court relies on.
Delay condone, issue notice, returnable on 9 September.
I'm grateful.
Service shall be made by all notes in police.
Item number 50.
It is very interesting questions, law evaluation on the 1/9+30.
Returnable on 16 September. Service shall be made by all modes including less.
That's the additional.
Thus, let me will serve on the standing council. Great.
Sorry, trustee permission is also granted. This effect service on the nominated of the standing council for the state of. With this.
Hello. 51 is a matter coming out after this matter. Hello, the learned SG is leading in this matter.
51.
Yes. The matter will take some time, my lords, on law. Lordship.
I'm for the successful resolution applicant.
There's no order here. We have not granted any.
But Lordship, what has happened is that DTCP is now not renewing the license, and my application
This is on merits.
allow me, sir. So now the plan is approved. There's no dispute. The people had come here, even that has been resolved. Now, because of the pendency of this, DTCP is not renewing the license. DTCP, the appellants, Department of Town and Country Planning. So because of that, the matter is not able to proceed.
What do they have to renew? Your
the license, and thereafter I have to start allotting the project. About 400 odd buyers are stuck despite the plan being approved because of the pendency of this. And in fact, we have factored in the principal amount of 19 crores, which was not made available by them, and we had filed an RTI, and we got that information. And after
that, you've already factored.
That we have factored.
Beyond that, how much more are there?
Now, they are asking for interest over and above, which they say that should also be considered, which comes over 27 CR. So that is
the interest part of it itself would work out to
27 CR, and they did not file their claim in time. They were barred by this thing, and 14 ceases to exist. 31 has come in. 31 plan has also been approved, and now they are here that they want to reopen that because of their default, they want to add on to that interest aspect to that.
37. My lords, that is how they look at it. And the position.
But you can't keep his application pending.
No, my lords.
He's already paid you
19 odd crores.
19 odd.
That's not the issue, which is
We'll say that pendency of this will not preclude
that
consideration of the.
That's the reason why we have approached my lords, and my lords were.
We are considering it. He's already paid you 19 crores to begin with. This SLP, the maintainability is
exactly.
In fact, yeah, that's correct, my lord. That's correct. The only issue was that when a CIRP starts under IBC, and on the day
your authorities think they are above the law.
No, my lord.
Do not go before the RC and make a claim.
Please understand, my lord. The explanation to section 14, it says that a license can be suspended if during that period the license fee is not paid. That's
why don't you make your claim before the RP? You think you are
that can't be done now because
you are healthy.
My lord, the amount is huge.
We see that in all these cases, none of the authorities go
before the question of law has to be. He can't, in the card of CIRP, my lords, he can't get the benefit of not paying the
request of the learned and request made on behalf of the learned assistant solicitor, learned solicitor general. The matter is adjourned. However, we make it clear that pendency of the special leave petition shall not preclude the petitioner from, not an appellant, petitioner from considering the application made by the successful resolution applicant on its own merits without reference to the pendency, without reference to the dues, alleged dues payable by it.
And more than not even that, they have paid more than 90% of the consideration with that because of
you paid to
the I mean,
sorry.
Yes. That's not what.
That's an
obliged so deeply. My lords, but since my lords have already stated in the order that my lords, everything will come in between because he will approach with an application seeking license, And if we have to give license, then it will have a bearing on the SLP, which is pending.
Even if you want the whole project to go down the drain just because you didn't get your money, which you never asked for within time.
It's all about the effective implementation. Of
Everything is beyond time. You don't go to the NCLT, nothing is beyond within time. And then you want to hold that over their heads and say that unless you pay the amount, I will not give you.
Absolutely not, my lord.
That is exactly what you're doing. You're just blackmailing them.
No, my lord.
Nothing short of it.
Absolutely not.
Nothing short of it.
My lord, are getting a date.
Take it up on a Monday at 2 o'clock, it will be taken off.
Apply, deep your.
Give you a date.
Any day, in second week of July. Any Mondays. Subject to my lord's convenience.
August?
That's my lord, because on the second week it will be a reopening.
Or a Friday also is all right.
As my lord.
What is
Friday will take. 8th August.
Also DPO.
It's on 8th August.
I am seeking a Passover, your lordships.
Item?
52, I am seeking a Passover.
52 perhaps requires a hearing.
Yes,
my lord.
No, we won't take it up.
My lord, I had mentioned it last week.
There's no point in asking for the matter to be taken up on the last.
Very limited prayer. Very limited prayer. I'll demonstrate. Please pass it over. Even I rushed from now.
Very good. Passport.
Thank you.
So, with your lordship's permission, in this matter, notices were issued.
This also requires a.
Definitely, your lordship. The only one thing which I want to point out is the petitioner, your lordship. Just one thing. Your lordship directed the matter to be listed on 6th of May before the Rajasthan Legislative Regulatory Commission. Now, what transpired there requires to be seen, your lordship. I just will pass on the order, which was passed by the Rajasthan Legislative Regulatory Commission in the matter. I may just.
Furnish a copy to the other side.
794.
Yes.
This is the second case.
Yes, sir. This is the big case.
Something about the first case.
Yeah, with regard to the PIL, your lordship, if I may, we just be permitted on this. Your lordship's representative appearing for SWML submitted some information during the hearing in the court. As per orders of the Honorable Supreme Court dated 4th April 2025, SWML was supposed to submit the records and data of monthly mining expenses. However, the information is merely statement showing average monthly mining expenses without supporting documents or records. Now, your lordships, just kindly see what they actually submitted, your lordship, and just the first page of that. Just one page I want to show from that. Lordship, it starts with saying, dear sir, we refer to the summons dated 24th May 2023. Now, your lordships, when the SLP was taken up, your lordships, the 24th May summons is on page 403, your lordships. That is what my learned senior had shown to you on that day. May kindly just have a look at page number 403, your lordships.
403 would be the second volume?
Yes, your lordship, second volume. 24th May 2020.
Volume? So, 403.
Yes, sir. Page number 403, annexure P14.
You've got so many volumes here. It's very difficult to know what is what.
Page
403.
Summon to witness.
Yes, sir. That's the summon to witness. They themselves are referring to that.
Go ahead.
Your lordships, this says summons to witness. The first line of the summons says, whereas white letter dated so and so, the commission order dated 21st April 2023. Your lordships, they themselves are admitting that they are coming in compliance of the summons which were issued on 24th May 2023. Thereafter, they say that the summons clearly specifically mentioned 21st April. Now, your lordships, 21st April order is on page 371. Just your lordships may kindly look at page 371 of this, your lordship. That is the order.
Yes.
And your lordships, the para 6.7 on page 377. Further, further in regard to of the details of the month-wise payments made by the petitioner to the MDO, that is SWML, commission-wide data gap dated so and so, asked to furnish the statement of invoices raised by the MDO along with details of the amount entertained or paid for all 5 years, along with the copies of the invoices for the month of March of all 5 years. This information was duly furnished by BLMCL, which is different. Now, para 6.8, your Lordship. The respondent DISCOMs desire SWML to furnish documentary evidence of the monthly expenses incurred by it from the year 2011-12. The said information is not available with the petitioner. The petitioner is a company owned 51% by Government of Rajasthan, has no access or means to access the monthly expenses incurred. Now, Your Lordship, I'll come straight away to the recording of what exactly the tribunal held eventually.
So where are you heading now for today?
For what? For today?
The reason why I'm showing this is, Your Lordships, they themselves are very well aware that they were supposed to submit not only a chart showing that this is the bill that is
They did not do that. Therefore,
so what they have done is they have not annexed the invoices. They have not annexed the invoices. Now, as a DISCOM, when I have been provided by RERC, first they say that this is confidential. This should not be shared with me at all. Then they file an affidavit which has till date not been served to me. Now, Your Lordships, firstly, these things should be submitted to me because I am the person who's supposed to look into it and see whether there is to submit back to RERC showing that there is a huge gap or whether there is a huge gap or not. And without the annexures, without the invoices, how will I exactly know how much the MDO billed exactly under what heads? Unless I know that, it will be impossible for me to correct the data.
you are now asking for.
Your Lordship, all I'm asking is firstly that this or information, whatever they provide to RERC, a copy has to be supplied to me in advance. One, and secondly, Your Lordship, more importantly, what I want is that.
What is the second one?
Second is only thing, this, Your Lordship, they have to comply in letter and spirit with the 21st April 2020 to the
RERC. Matters still pending, is it?
In fact, the information was submitted. The RERC said, file an affidavit saying that this is true and correct. They have filed that also.
They didn't give me a copy.
I'm not going to fight on that.
That you need an order.
I'm not going to fight on that. We've also filed it part of the compliance affidavit before your lordships. This same SLP.
Whatever it is you are filing before the RERC, give them.
Surely, nobody can quarrel with that.
Complaint is that you're not sharing it with
You're not sharing it. If I want to give me a phone call outside the court,
we just give you a date. Do all that you need to.
Plus, the issue is, can you consider?
Yes.
The issue is not serious for the jurisdiction. Can the RERC?
I'll have to hear you. I'll have to hear you, not today. Not today. We'll hear you on a Monday or a Friday.
Your Lordship, I appear on behalf of RERC.
25th July.
Interim order, of course, may have to be extended because the last order said that till next date of hearing, no final order.
I've already got it.
No, it's till the next date of hearing.
Yes, the interim order shall stand extended.
Your Lordship, I appear on behalf of RERC, would like to make some submissions.
Not today. Not today.
So the order has
not
been complied with. So Your Lordship may issue direction, they comply with the order. What was asked for a mining
22nd
expense, they have submitted.
22nd August.
22nd August.
22nd August.
Very great.
We'll hear you on that.
Your Lordship.
Is that so? Individual and yes, individual group.
Yes, that's the identity, Mother, the issue of his identity. This is a matter, Mother, that your lordships have to consider because what it does is there's a Section 7 application filed. He knows, Mother, ultimately it's going to lead to a appointment of a resolution, professional, Mother. So what he does is he floats a company in October of 2020. He floats a company in October. He has 99.7 odd % in that company, and
Requires to be heard, Mr.
That's right.
We'll give you a date.
Your plan is operating.
The plan is fully implemented. The COC is here, the RP is here, I am the successful resolution applicant.
it's fully implemented, Lordship may issue notice, but there is no notice.
Notice.
That's right. Well, one more thing. And for final disposal.
We are asking. We are asking. No.
Yeah, two more were answered. That's why we have.
Because may I make this one submission?
Issue notice returnable on September 13th. Reading shall be completed by the set date so that the matter can be taken up for hearing.
Delay the control, there is a
Delay control.
decrease.
Delay within the.
Delay is that within the, Mr. Sibbal, what is the delay?
Within the period.
Oh, it's refund.
Sorry. This is how I get instructed.
Only with all due respect, with all due respect,
Has been implemented.
Very well.
No, I am only saying that the Lordships are deciding an academic issue today because.
Not today.
No, I am saying even when your Lordship.
We'll see whether they have a.
MIT has given approval, my lord, to the transfer of
The
license.
Ministry of Information and Broadcasting has approved our license.
That also
The
is
license
not.
is going on.
What's the point of when the order is passed? What's the point of saying all
We'll
that?
ask him.
I know that.
And he participated in the proceedings completely. He was satisfied. The COC meeting record.
Consider on that day, Mr. Emily.
No, I'm only saying that
It cannot be academic in that sense. If we find a point in what Mr. Sibbal is saying, then the entire process may have to be undone.
pointed out the point which could be taken
But not academic.
Look, the definition of group is very clear. my lord.
That is our third council will argue.
No, for the COC.
After the order is passed, this is the new practice we have.
Page 54. Sorry, item 54.
55.
55.
There are two aspects. Number one, they get a conditional stay, 75% deposit, they don't make it. Number two, my lord, from September, they are here. From September 2000.
It's an interim order, Mr.
Lord, they are occupying the commercial property, they have to pay some rent.
Take it up with the High Court. The High Court sees
rent.
High Court has recorded that he will get instruction.
In January, February, we are already deposited, Lordship, more than 43 lakhs.
55 lakhs, 75%, 18%
Matter
interest.
is listed on 5th June.
Yes,
we
it
have
is.
already.
Lord, they are here, please put them to term, let them pay the commercial rent.
Take it up with the High Court, Mr.
No, I'll not take both in the meeting. This
The
is
High Court
very
has
private.
recorded in that impugned order that they will also take instructions on the 75% as well as the rent, shortfall of rent.
1 minute, Lord, that's not a shortfall of rent, Lord. May I just indicate, 2023 September onwards, please ask them, Lord, they are occupying a commercial property.
We are not going to ask them anything. Get the High Court to ask them. We are not inclined to entertain.
Will your Lordship?
Especially a petition against an interim order. Delay condemnation. The especially petition is accordingly dismissed. This order shall not preclude the petitioner from pursuing his remedy before the pending pursuing his remedy in the pending writ petition.
It will be an
Pending
appeal.
appeal before the High Court.
Issue on my.
I'm ready.
You have other remedies, you have the federal and.
Yes, my Lord, but
They have not complied with the
they
order.
road property, my Lord, they are occupying.
You must know how to exercise your rights.
Yes,
Have
yes.
you applied for the federal motors?
Lordship, they are.
That's Lord, we have to do that. Lord, but we had made an application before the High Court which has been rejected. It was earlier.
Out of.
₹90,000. Saint Mark's Road property, my Lord. They are running it as a hotel.
Deeming, they are.
90,000 rupees is what?
They are
Yes.
taking that position.
I bow down. I bow down.
Allowed respondents remedy in an.
I bow down.
I
bow down.
Leon.
Wait.
Great business.
So remand order.
What is the remand is the reason why we are before a Lordship. Kindly see paragraph page 6. Well, it's para 17 of the original order has not been complied. That is the reason which I got page into judgment words page 6. Top line. This is the reason to setting aside order passed by the registrar. Looks like we're starting the line. But without complying the direction in para 17 of the kindly come to para 17 words. That is page 40. Well, this is the person whose case has been rejected by even the additional district judge in the first round by saying that he is not coming with the truth. Same person, this is a paragraph 17.
Page 40, is it?
Page 41. So I'm not questioning the Lordship. Kindly come to page 41.
The registrar should take immediate action in this regard as per the rules and immediately call a meeting and constitute a trust and appoint trustees, make arrangements for trust bank management and conduct a proper investigation regarding the trustee, other persons guilty of illegal misappropriation and irregularities of the trust property. Take action for recovery from the guilty of persons to compensate the loss caused to the trust and take necessary action in relation to the civil and criminal. They are not part of the first part because we are really into this. The registrar will be free to consider the names of the 9 proposed persons, keeping in mind trustees' conduct and nature being a religious nature and his inclination towards the religion as well as keeping in view of the religious sentiments of the people, keeping in view of the secretary and the safeguarding interest of the trust. Now kindly come to my lords, the order passed by the registrar now. Third, my lords, page 50. Starts at 43, lords come to page 50.
Yes.
My lords, E is the direction, then 5. My lords, I am not reading. He conducted a meeting, my lords, and considered the names and verification was sent to the police. Police have given a report, my lords, by 50 and it's according to the no crime has been found registered against the above proposed 9 trustees. Part 2, 3. Then we discuss completely this person's qualification, my lords. Finally, the registrar passed an order as per the
Where is the discussion on the other aspects, religious as what has been mentioned in that paragraph?
That's coming, my lords.
He only gives them a clean sheet with regard to the.
No, not only that, my lords. Antecedents, my lords, that's coming in the earlier paragraph itself. Because the earlier paragraphs records, my lords, these people have been selected as per the committee. That is.
There's no discussion on the other aspects which are mentioned in
page 49. Page 49. Paragraph B. This is what directions given, my lords?
Religious sentiments to see. To see. Where does he see though? He says, I need to see.
Yes, my lord. That's what.
Where does he see after?
My lord, he says, my lord, in the paragraph.
He doesn't see.
Well,
that is the reason why it's remand.
No, it's seen, my lord. That's why.
No, he says, keeping in mind, it is necessary for the registrar to see.
Yes, my lord.
So thereafter, show us where he sees.
Paragraph 6 onwards, my lord. Paragraph 5, I read it, my lord. Police report. Paragraph 6 onwards. Page 53, the Honorable 4th Additional District Director has clarified there was no too many complaints against the man Sam Sundar Das. This is the person against whom it was not considered.
So this is only on the issue of complaints and all that. Those other religious aspects which he is supposed to look into.
Paragraph 7, in the case of the statement of the proposed trustees, applicant side, so and so have been, they will be operated the trust by protecting
the remand order. Go back to the registrar.
Why I am saying that this Suryakant Tiwari, my lord, he is the person. Can you see the observation against him in the early round of litigation?
This kind of trust, anyhow, these politics are bound to be.
Well, this one person keep on for 15 years agitating the case, not permitting anybody to
trying to interfere with the order, which is in the nature of a remand order, especially petitions for coming to the least.
Well, on this. Against item 58. Item 58 and the. So sorry, item 58 and led by Mr. Mukul Roy. He was in court just 2 minutes ago. I'm praying for a Passover. He's on his legs in court level.
Passover? Okay, I has. Passover.
Well, I should just seek permission for the Passover.
59 also. Sorry. 60 also Passover?
Yes, Your Lordship.
You'll have to get command.
Well, the 61 minutes, the entire controversy minutes.
One moment, one. Yes.
The entire controversy hearing, my lord, is covered by the judgment of Hitesh Verma, my lord. I will show, my lord. I will show. My lord, my lord may have this particular transcript, my lord. My lord, the complainant himself says that, my lord, the voice was coming from the shaft. Ventilation shaft is always inside the house, my lord. It's coming from the shaft, my lord.
with the two daughters also.
Yes, my lord. There is nothing against the daughters, my lord. None of the witnesses have said anything against the daughters. They have proved in the daughters or the mother is retired. They are students, my lord. They are suffering for 5 years. Let's stay. In the meeting.
How old are the daughters?
My lords, one is 30 and my lords, one is 24, 25.
Returnable on 7th October.
My lords, stay in the meeting.
Stay off.
Trial court proceedings, my lord.
What is the case number?
My lords, it's SC 36 of 25.
Which page?
Page, my lords, in the page 29. 29, my lords. Para 829.
Please stay off further proceedings. In SC number 36 of 2020, pending on the file of the learned ASG-2, Additional Sessions Judge -2, come Special Judge NDPS, Northwest, Rohini Court, Delhi.
Much
till the next date of hearing.
62.
62.
Yes. May I please, my lords? My lords, this is a case where I am a foreign investor. Two professional directors, my lords, I have made a complaint against them because they've done large mismanagement, siphoning of a fund, selling of the company, doing all kinds of illegal activities. I, right or wrong, filed a police complaint. Police, without summoning the main director, who's now, my lords, left India, files a closure report. I go rushing to the High Court. I say, without any investigation, they filed a closure report. High Court, my lords, in all fairness, comes down heavily on the police and says, please conduct further investigation by the Special Commissioner and relook at this entire matter. My lords, in the relook at the matter, they simply, my lords, adopt the stand in the first report. Just say, this is what is the report says, we agree. This is what we say, we agree. Now, my lords, something has come out very serious. They, in their report, I want to show you just 2 pages because, my lords, me coming to a constitutional court.
What is the direction, Mr.
Because direction is go back to the magistrate's court. The problem is that under 178(3), if I go back to the magistrate's court, they can't order re-investigation. That is a constitutional power that can only be exercised by this court as per Vinay Tyagi. C7, Milos, I want to show you 2 things, then Milos, I will answer.
Who are the complainant?
I am the complainant.
There is a closure report. What is your remedy under Bhagwan's?
Well, my remedy is that I challenge by way of a protest petition under 17338, but the problem is something else, Milos.
Not 173. Bhagwan Singh gives you a remedy to protest petition.
But Milos,
petition,
which will be
if
treated
you
as
want
a
further investigation, then you go for 173.
They have Milos just as a post box filed another closure report without even applying their mind.
Now the court merely directs the magistrate to consider all the applications.
Milos, as per Bhagwan Singh,
where is the cause for grievance?
That's what I want to answer. Milos, the only way I can get a re-investigation ordered in law is by way of
not re-investigation, further investigation.
Milos, further investigation, the same police station, the same office is doing it and nothing is coming out. Can I just show you one thing and then Milos, I will leave it at that. Just see page 705. My lords will see what they've done. Actually, why is the case for re-investigation? This is last point. Milos, just see 705, something very interesting.
You literally want us to step into the shoes of the magistrate.
No, Milos, I am asking Milos that your lordship would always direct the police to give it to a different department and re-investigate this case.
Thereafter, you have to go through
Milos, that goes into Milos, I tell you why. Just let me show page 7. Let me show you 1 point, then I'll answer. Please see 705 bottom. Something against me. This is the status report filed after further investigation. During the course of investigation, laptops and hard disks were seized from the office of NextGen Pharma. My entire complaint is this NextGen Pharma is a shadow company. And the same was subject to analysis by this forensic RFSL. Specifically queried from FSL as to whether this agreement was found to be prepared in any of the laptops seized. However, no such document was found. So, Milos, in their favor against me. Now, please see what they sent to the forensic. One black sealed NK containing a suit's laptop.
All these aspects.
Just see. Now see the FSL.
We filed.
Just
you already filed an application.
No,
application.
I'm sorry. I'm showing you something very interesting. Milords have seen that it is one laptop.
For us to see at this
stage. Something very glaring. You've seen that one laptop that they have sent to FSL, and the FSL says there is no agreement in that laptop. Nothing is found. Now please see 488. They send the laptop without the hard disk.
They're showing something interesting for you for obvious reasons.
Because they send the laptop without the hard disk. Without the hard disk. So laptop is gone. Hard disk is never gone for examination. And the police files a separate report again.
Ground and reason to interfere with the impugn judgment, especially if that's according to dismissed.
Oh, bless you.
You have to see what is listed. If an touches in any event.
My lord, it's seeking a review of a lordship's order.
Even they wanted to go before the same bench.
My lord,
now it can't go before the same bench.
No, my lord,
So there ends
this
the
prayer was made on 9th, my lord.
Sir, just Passover.
My lord, please see the order.
And I've seen that also. They are now trying to read something into what we might have thought of
that.
Because we never even said anything.
And my lord,
in fact, we came down on you for taking the possession of the property in a manner which.
My lord, on 9th of April. 9th of April, your lord.
And now the order, this application says that we wanted that money to be.
Exactly, my lord. And my lord, 9th April, your lordship is very on the same honorable bench. Said, let it go to the other way. Please see your lordship's order.
I've seen that order.
13, my lord.
Madam must have come up with
It came up with your lordship on 13th, my lord.
They said go back to court one.
Yes, but and no, my lord. What happened is your lordship sent it to my lord Justice Pardiwala's court. These people, they go there, file this application and say it has to be listed before the chief's court, Honorable Chief Justice's court. Then it comes back to your lordship's court. When your lordship has already passed at page 13, please see page 13, my lord, of that IA. Your lordship's order. This honorable bench has passed that order. Please see, my lord.
This before.
And then 13.5 days
Subject to orders. Subject to orders of Honorable Chief Justice, list before bench presiding.
After this,
it goes to the court. It goes to that court. Then they bring it back here. They say that your lordship should hear it.
You can't choose the bench.
Just Passover, sir.
And even if you have this illusion that I'm going to be sympathetic, I'm not.
Passover, just keep it after lunch if possible.
Very good. Passover.
Very good, man. Please, oblige.
In item 64, my lord, I have received some documents, my lord, which I want to place before the honorable court, madam. You are actually High Court has regarded.
Before the High Court, what did you produce? The High Court says not to produce the guidelines.
High Court has guidelines. High Court has wrongly regarded finding, my lord. That's why, my lord, I want.
I've also looked at your writ petition, Mr. Mr.
Yes, my lord.
What do you say in your writ petition?
My lord, the first.
What is the violation of the guidelines according to your writ petition? Please point out.
My lord, your RCP means the High Court first paragraph is incorrect, my lord.
Leave that.
That's why
your writ petition. Let us see what you have raised.
Yes, my lord.
What did you say then? What are the violations according to
violations are there, my lord?
What violations in your writ petition you point out, please?
Yes, your RCP just see, my lord. That's why I want to find some documents, my lord.
You are just building up the case as you go along. Before the High Court, you got nothing. So now we will have something else.
Actually, my lord, some papers, my lord. This is a case of a fraud. I am telling you, your RC, my lord. Other side has not stated the correct facts, my lord. Even the High Court has regarded the incorrect.
You have to at least demonstrate what the violation of the guidelines.
My lord, I will, my lord. RC, just grant me, my lord, 2 weeks time, my lord.
The request of the land comes.
After vacation, my lord, I will.
Why do you get listed on the last day then?
Matter as adjourned to enable him to.
We received, my lord, since the client has come in the morning, we received some papers, my lord, which are very, very relevant, my lord. I do that.
We continue on.
See. After vacation, my lord.
Yes.
Any date, my lord.
5th August.
My lords, I am for petition in item 26, my lord. Senior appeared, but due to some technical glitch, we could not.
What happened to it now? Matter was adjourned or what happened?
My lords, I was not present at that time, my lords.
Item?
Senior appeared.
Item number?
CB Raj.
Item 36.
26. Will he confirm this?
26.
Will they condone dismiss? Matter was heard.
Gururaj appeared. Gururaj was here. She said adverse possession matter.
Please, my lord.
Counsel appear. What do you want?
Appearance slip.
Oh, appearance.
Malad, may I mention item 51?
We are going to come back again.
Please, Malad.
In 66, Malad, I don't know whether Viswanathan would like to hear the matter.
What is 66?
One of the parties in 66.
Yes.
Yes.
I shouldn't hear it, or my brother should hear it.
I have appeared for them. In this matter?
In what they will.
That's
Those parties are not here. Someone.
Venture.
Who is the party?
It's India Records.
No, unless I have appeared in this stream of proceedings.
It's not it.
Otherwise, first 6 months I was doing that. Otherwise, you see, I was burdening my brothers. So I said, first 6 months.
After that, detachment sets in.
Absolutely. Just.
Item number 4.
Fourth,
Ready to appear for the state.
Let's kindly pass over Mr. Luchai's leave. Mr. Luchai, set a bill at least. Mr. Luchai's leave. Let's see, sir.
Lordship, this is a matter where the consolidated, all the states, all the FIR, over 100 almost FIR, they have been consolidated and they are now being tried in Ghaziabad. Lordships, they have been put together. Out of this, there might be about 30 FIRs of UP, some about 26 of Rajasthan. So he is a person, Lordships, who has duped large number of people. On his saying, the whole matter was.
let us see what Mr. Luthra has to. You may be safer inside, Mr. Luthra. 2,46,462 people looking out for you.
Actually, I must tell your Lordship, there are various.
One of them might be desperate enough to resort to.
Lord, they kept. Lord, I must
Maybe,
tell you,
maybe you're safer inside.
I spent a fair amount of time inside now. Lord,
maybe you'll still be safer inside only.
I think your Lordship, he's been in since 2020.
But look at the figure.
But not me.
2,976,000 crores.
Let me show your Lordship one very interesting order. Lord, please come to P41. This my friend is, and I've been discharged in Rajasthan cases.
That order we said we would look into.
That's your Lordship bill. But today, Lord, please, the Rajasthan has taken a stand. I'll leave it to you, Lord.
Some more months, I think, let him remain
Can
inside.
I show you one thing, Lord?
We'll just adjourn the matter as it is.
My Lord, can I show you one order, if I may try? Just one. Just tell you one order. Just one. Just see not P41 as to how this man has not been put to suffering. 224. I leave it to your Lordship.
Sorry, which
P41 to P41 at 224. As a council note, decide I'm happy to let you fight another day, but just have a look at this.
Yes.
My Lord, forget this FIR, Lord, which he's in, where there are now 2,000 witnesses and the matter is not proceeding. Please see 241. My Lord, ED put him in custody. Now see this order for a moment. By order dated 28th of May, passed by the session judge, 3 companies were summoned to stand trial. Director of Enforcement, appellant Sachin Bhatti has not been named as an accused.
Which page is reading?
241? No, Lord, 224, next to 321.
220. Yes.
By order dated 28th of May, passed by the session judge, 3 companies, Pimex, Prerna and Pimex, were summoned to stand as trial in enforcement report number so-and-so in Lucknow under 3 and 4. Appellant Sachin Bhatti has not been named as an accused. Summoning order dated 20th of May, however, directs that Pimex, Prerna and Pimex shall be represented by the appellant Sachin Bhatti, who is one of the directors in the company. Appellant Sachin Bhatti, on his appearance before the trial court as a representative for company's white dated so-and-so, was remanded to district jail by another order. The session judge rejected the bail. Appellant has challenged the order, but the prayer for bail has been dismissed. Unfortunately, Lord, whoever the counsel was, filed bails in a matter he was not summoned. Having regard to the fact that the appellant is not an accused in his individual capacity, we do not think trial court was right in either directing appellant Sachin to appear as authorized representative or in sending him to judicial custody. Aforesaid companies are being prosecuted and can be represented by any person, and he was released. And now, my Lord, I'll leave it to your Lordship, but just see the counter of the state, Lord, for a moment. Their entire case as against me is.
We'll consider after in July.
I'll leave it.
Matter is adjourned. Let's strong.
Perhaps the monsoon will bring some cheer to my client.
Yes, one. 23rd July.
Ready?
May I please smile next? Allow them appearing for the responding.
May it please, Lord. Lord, this is, with all due respect, Lord, the kind of a strange case for the reason that my land is acquired, I am not paid compensation. Thereafter, my land is given to the respondent in exchange for his land, not returned to me. Lord, I challenge that the High Court dismisses. I come to your Lordships. Your Lordships, Lord, issued notice granted stay. A settlement is arrived at that I have a share in 2011. Your Lordship disposed of the matter in 2011.
Yes.
Till 2018, nothing happened. And then I find out that the Haryana Shahri Vikas Pradhikaran, which is equivalent to Huda, has got the name mutated in their name. It is not in the name of my learned friend. I have a share, and no development takes place till today. Land is lying vacant. And I challenge and suit that the mutation must go, and whatever my share is, you partition and give it to me. Because that is recorded in the settlement. That matter is now not referred to arbitration under Section 8 without deciding the arbitrability co-mutation.
Your suit is not filed against HSVP.
No, it is
HSVP.
No, I filed an order 1 Rule 10 which is pending without moving.
Order 1 Rule 10.
What's the order
Yes.
1 Rule 10?
Let
my
me
friend.
complete
I apologize.
thereafter. Yes.
So my order 1 Rule 10 is still pending. The High Court notices that. And that is not decided. So here the trial court, while granting Section 8, says your suit is dismissed, which also the High Court has corrected it on Order 7 Rule 11.
Yes.
The prayer is 70.
Yes, Lord. If you Lordship see the first suit plot, which is at page 62, the prayer is at 71.
71.
The prayer is at 71.
Yes.
May I place it, Lord?
Yes.
It is therefore most humbly pray that a decree for declaration may kindly be passed in favor of plaintiff and against the defendant, with cause declaring all the revenue entries as mentioned above in relation to pursued property, showing the partition of such and such as illegal, arbitrary, fraudulent, unconstitutional, null and void, liable to be set aside with consequential relief of permanent injunction, restraining defendant, its associates, employees, etc. from assigning or interfering with the possession, and then also prayed that a preliminary decree for partition of the said land, measuring such and such by metes and bounds, may kindly be passed in favor of plaintiff against the defendant, with cause keeping in view the fact that every owner of the suit land is entitled to get a proper passage on the road, and the defendant be agreed to allot the land as shown in red color in the site plan. So, the settlement record that I have 1.39 acres or 27 point odd shares, 27.5% share in the entire land in the settlement. Now, they were supposed to develop. They did not do any development till date. Even today, the land is lying vacant. They got an allotment from Huda in 2003. And thereafter, the land is recorded and mutated in favor of Huda, not in favor of the... And my land in exchange, why given to him if there was no requirement for acquisition? That was my challenge before your Lordship then. So, Section 8, they should have seen whether this is arbitrable at all. Insofar as my arbitration application, which was allowed without Section 11, I must inform your Lordship, I had filed a Section 9 and a Section 11. 9, I got an order. Section 11, matter referred to arbitration. That is with reference to the working out of the settlement itself. It had not...
Let us see your settlement. What exactly?
Yes, Lord, your Lordship, it's quoted in the impugned judgment, my Lord. If your Lordship will kind...
It's at page 49.
Sorry, my Lord.
It's at page 49, my Lord. The
I will show the entire... No problem, my Lord. According to me, it's extracted fully. But in any case, my Lord, I will read from page 49. The parties are mentioned. Parties are so and so original owners. So I am the original owners of the entire land. It mentioned at the foot of the page. State of Haryana issued a notification under 4 proposing to acquire 2 bigha 4. This is equivalent to 1.39 acres. Comprised in first party to agree challenge the notification under 4. Subsequent under 6 by writ petition, which was dismissed as withdrawn. During this period, on a representation of party 2, Huda transferred the land measuring 1.39 acres, which incidentally also formed part of the land which belonged to party 1. Party number 2 was directed to submit layout plan and area further development. So they were given a permission to exploit commercially. Haryana, Huda thereafter on application has revised from time granted license and regulation of urban area was the development of commercial colony land measuring 3.25. That is a larger area. That is why, my Lord, I have only 27.5. At this stage, filed a writ petition challenging both the notifications. High Court of Punjab and Haryana and also challenged the order 17.7. Meanwhile, Huda issued a letter ordering that the letter of intent dated so and so, which was kept in abeyance, stands revived, and the party 2 was directed to deposit so and so fee. The party number 2 complied. Then next, my Lord, the said writ petition was contested by the party as well as State of Haryana and dismissed. The said judgment was so and so. SLP challenge. Then SLP, my Lord, your Lordship, see the order in para I. The above mentioned SLP being so and so came up, issue notice And then, my lord, until further order, directed status quo in the matter. Terms of settlement are on page 52. In view of the fact,
this MOS also deals with the same land which
Absolutely, my
is
lord.
not sorry.
MOS deals with the same land which is the subject matter of the suit.
Quite so. So 1.39 acres. But I am saying, my lord, what I challenged was the mutation in favor of Huda. But with all due respect, Huda is not the owner of that land. Huda says that I have exchanged some other land, taken away land, given my land to my friend. That was on the condition that I will get something out of it. Because that the development will take place, etc. So regarding that development, that section 11 is
what exactly is the scope of the arbitration that you have initiated?
Yes, my lord. Your lordship will see my prayer in the section 11 application, my lord, which is that way. My friend,
The statement of claim is
right. Your lordship will see my prayer, my lord, at page 182, 158. My section 11 starts.
182.
158. It starts at 182.
Yeah. No, but in what context? What is the arbitration?
Yes, my lord. Your lordship will come. Yeah, sorry, my lord.
Claim
My lord, kindly come to 166. The dispute and the relief sought. The para 80, following is a summary of the dispute. This petitioners were owners. 97 acquired. Then after acquisition, petitioners were left with land so and so. Thereafter, my lord, para 4. It is mentioned that the above acquired land of petitioner was illegally given to so and so, which is not the subject matter with the Huda exchange with them. Then para page 168, this is the challenge about 4 to 6, which we filed. Then the Supreme Court order of your lordships is mentioned. Then in para 7, the settlement is recorded at page 169, 170, goes up to 171. And then para 8 will be seen at 171. As per the above memorandum of settlement, it was agreed between the parties that petitioners possess right, title, and interest in the licensed land to the extent of 27.5 share or are entitled to get so and so in the sale proceed. Also agreed between that a separate site plan shall be drawn in respect of 1 bighah of land remaining after acquisition, which shall continue under the ownership and possession of the petitioner. This was the balance land which I had left over from my earlier entire area of land. Consequent upon execution of agreement, the petitioner moved an application for withdrawal. In view of the above, Honorable Supreme Court was pleased to dispose of. Submitted even after the execution of memorandum and withdrawal, petitioners continued to be in possession since the respondent failed to prepare a site plan as agreed between the parties as per terms and conditions of the memorandum. In order to show an ownership and possession of the petitioner of the remaining land as shown in so. In this regard, petitioners have been repeatedly requesting the respondent to adhere to the terms and conditions of the settlement. So what I am seeking is, my lord, the memorandum of settlement to be worked out, not being worked out. My lord, if you lordship see para 11. So, my lord, this was the subject matter of my section 11. To work out the memorandum.
But in para 11, you also refer to mutation issues.
And at
Yes.
13 also.
No, that
Please wait till the atlas completes. You need not be anxious. If we need to hear you, we will hear you.
I apologize.
But para 11 mutation part is mentioned, my lord. Even in para 12 it is mentioned. I am not.
No,
I am
but
not
once you say that this mutation issue is also part of the.
No, this is as a matter of fact. I am stating it before in the section 11.
No,
that is
you mentioned it in the context of what all issues arise.
what all happened. No, this is in the context of the dispute and the relief sought. The relief sought, my lord, if your lordship see a page number, kindly come to.
Did you issue an arbitration notice?
Yes.
My lord, there's arbitration agreement is mentioned. My lord.
Notice.
Yes.
Notice, what did you say in your notice?
The copy of the above notice, my lord, that notice is not
21.
notice is not, my lord.
We have made
Fair.
violation.
Page 180. But
This is
para
what you
21.
said in your arbitration.
Yes, my lords. My lords,
Para-
page 1
para-
is the notice.
Page 180, para 21.
Page 1 is the notice dated 15th of June
15th
2021, my
June
lords.
20.
And
Can we get copies
Yes, ma'am.
of what you're doing?
yes, sir. Yes. I apologize. And my lords, the paragraph.
Again,
Mutate, sir.
we just wanted the notice,
Right, my lords.
not your argument.
Right, my lords.
Yes, yes, Mr. You've not seen the notice at all, Jay?
Sorry, Lord.
You've not seen this notice at all?
No, my lord, I have not seen this notice. I must admit, my lord. My notice is mentioned in para 21. But I'm trying to locate the notice in my friends, my lord.
It's at
Yes, my lord, page number 1. The notice is at page 1. And there your lordship will come straight away to
Page 7.
the,
Page 7. Perusal of the Jamma.
in para 11, there is a mention, my lord, to change.
Haryana Shahidi Vikas, where the currents are shown to be the owner. You've squarely raised the issue at page 7.
Page 7, para 11.
The
That
mutation part of it.
Yes, my lord. Yes.
Para 10.
It is mentioned, my lord.
Para 10, you also
Para 10 also that they found out about the Jama Bandi.
shown there.
It is submitted Haryana Shahri Vikas Pradhikaran cannot be the owner of the land.
So you raised this issue also.
No, I am.
So even if
No, but
OAS is not
Lord,
between.
what is it that I have asked you, Lord, if your lordship will kindly allow me that, if your lordship will kindly allow me that para 17 and 18, what is it that I have asked for
In the notice?
in this notice? Kindly allow me. Para 17 and 18. It is highlighted that the applicants have complied with all obligations set upon them under the memorandum. Notices have specifically failed to perform their obligation. 18. The aforesaid gross failure does not only tantamount to violation of the term, but further amount to serious and deliberate act of breach of trust. Cheating caused not only a severe inconvenience, hardship, and mental agony. Despite constant efforts.
Leave all those words. Earlier, para 15, you say that notices in collusion with the authorities are trying to dispossess. And in that context, you raise the mutation issue.
No, Milord, they are trying to dispossess. I have to file a different suit, Milord. My suit of 2021 was also there. I have filed a 2021.
Both.
No, Milord,
You've initiated arbitration proceedings. You yourself say that this is an arbitration.
Milord, I am only
issue.
With all due respect, Milord. May I just.
Sorry, Mr. Ranjit Kumar.
Milord, only this
really
much.
find no ground to.
Only this much.
Yes.
Milord, then, Milord, if arbitration which has been filed, the claim that has been filed does not relate to this. I wanted to say this. I may be permitted then to.
You raise it.
No, I'm saying I should not be precluded that I will not be able to file.
You have the Section 8 order. You're not interfering with it.
No, Section 8 order and it's gone to the same honorable judge. Milord, where the arbitration is pending, so I'm only seeking that liberty.
Place that Section 8 order to
No,
say that
Section
your
8 order
will be dismissed on this ground that the matter needs to be sent to arbitration. So
No,
I'm not going to say anything.
No, only one line, Milord.
So
Milord, I am entitled to Milord make pleadings.
My lords, if I may just.
Because I have not made any pleading.
Here with the impugned judgment.
My lords, the SOC says so, my lords. Claim 1, if I may just.
It is open to the petitioner to take recourse to the arbitration proceedings in the light of the dismissal of his suit.
My lords, if I may just show.
Not dismissal of the suit.
Adjourned Senator. Or is it dismissed?
No, it's the High Court noted that it was wrongly dismissed under Order 7 to 11.
So it's now adjourned Senator.
Yeah, so adjourned pending the.
Adjourned Senator. By virtue of the order passed under Section 8 of the Arbitration and Conciliation Act.
Lordship
1996.
Yes. All issues get referred under
My lords, in fact, if I may just add one line because this is already over, the statement of claim, the first prayer made by them is determination of title of mutation entries. That's the first prayer in the arbitration.
The claim petition.
Yes, my lords. Obliged, my lords. Very grateful.
Wait, please, my lord.
52.
My lords, in 52, if I may just indicate the reason why I requested for the listing this week. My lords, since 17th March, we have been mentioning this matter. The only reason is very limited relief.
And then you get it listed on the last.
My lords, actually, Justice Viswanathan will remember that we have been actually before different benches.
The third award.
Yes.
Yes,
Third
because
award.
which is like
Third award.
third award after the one has
Can I just get
No, you may have a case, but then let us have a
I am
We have
not
a
on
proper
that.
hearing.
I am not. Can I just?
Sadhana Jadhav was to mediate. No, that-
Yes, can I therefore just
What is the
mention?
immediate urgency?
Yes, I will only limit myself to the urgency.
What is the urgency?
My lords had referred us to mediation because this is partition between two brothers. Properties have to be equally divided. Now, during the mediation, they have alienated several properties which came to their shares and some which ought to come to our share. So be that as it may, today my only humble submission before the court is, my lords, when there is a family partition and the High Court order says that bring everything into the hodgepodge and then directs the executing court to partition. Now, if that High Court order is not stayed by my lords, on the contrary, my lords tell us to mediate and try and resolve, we fail. We fail. But, my lords, it stands to reason that both families should therefore hold on to the properties because otherwise they are rendering the proceedings infructuous, my lords.
They are selling of properties.
Yes, my lords, please see, my lords,
You can undertake this. You can undertake till July.
May I,
Don't sell
I
any
had that
properties.
protection in High Court.
can
I had that protection.
Do you have the authority to give us an undertaking that you will not sell properties in the next stage?
can I just make a?
Then we'll make it an order then. If you do not have, why should we
Just
fill it
give
in?
me half a minute.
But we are going to hear the matter, Mr. Arora. Don't
I have no problem. My lords may keep the matter next week.
Transaction.
Lords, can we just answer?
My lords, I have not
This
finished.
is completely unfair.
That we will hear. We are not prejudiced as we now. In the meanwhile, don't sell any properties.
That's all.
My lords may
If
keep
my
the matter in July.
We will also
I will
Both parties.
any property in the
My
middle.
lords, can I
In
quote
July,
the
my lords,
undertaking we
we
gave in
give
the High Court? Both of us gave an undertaking in the High Court. Then
This is.
No undertaking, we'll record it.
This is
status quo all properties.
My lords, no, there are properties which have come to my share, which has been sold.
But there is no question of
Nothing
my
about
share and
it.
their share.
Don't sell now.
I'm not hereafter, not today and hereafter. That is what I'm saying.
Yes, power of attorney holders should also not sell.
My lords, that can't be.
But my lords, I have placed all of those documents in the application. How can that not be?
That cannot.
My lords, if they are giving power of attorneys to sell, if they are achieving the same
My
objective.
lords,
Let's listen to the order.
Power of attorney holders are separate.
my lords, I say
My
that
lords,
as of
I
today,
agree.
whatever has not been sold will not be sold.
Including
I
your,
have said that.
including your GPAs. They are acting on
My
your
lords, if
behalf.
they act upon my instructions, I accept that they will not. But what has already been disposed of, they can be.
You're not touching what is being disposed of.
I am talking.
Properties henceforth shall not be sold by both parties, either by themselves or through their power of attorney.
My lords, may record.
My lord,
And
100
my
is
lords,
strong plot.
may-
100
Getting the order. We get.
My lords, may give me a date in July.
July.
This requires
18 July, we'll take it up at 2.
grateful, much obliged. I'm
Based on July 18, matter will be taken up for hearing at 2 p.m.
on the other hand.
In the meanwhile, both parties are restrained from selling their properties, be it by themselves or through their power of attorney holders.
Grateful, my lords.
Obliged.
Item number
58.
My lords, Mr. Bharti is in 58, leaving 58. I am in 59.
Miss
So
Nandi,
these are distinct but similar. I'll come
when,
up with.
when we were hearing the matter, all of you asserted that we are not part of the tainted group. Now suddenly you have a doubt as to who would be tainted, who would not be tainted. How is it possible?
Today we are on level.
When all of you argue,
Can I
said,
get my
we are not tainted, we are not tainted. And this is the first statement made by each of you when you started your arguments. Each of you, we do not belong to the tainted. We are not allowed to. You are practically asking for a review.
May I just make my
Review is also filed, my lord. They filed the review now, I mean.
Review is still
Can I
pending.
make my,
Review is perhaps dismissed already.
No, another review.
No.
They say so in the application.
But they will allow, my friends should have some patience, allow me to make a point here. I am also aware that there is a judgment against me, I am aware that we were there, I am making a very simple point. And the point is this, that in the judgment of the High Court which you have affirmed, there are 3 classes mentioned who have to refund salaries. 1, who are beyond the matter. 2, who are beyond after the expiry, and 3, who have blank OMRs.
But the High Court does not say anywhere that these are the only categories that are.
Yes. It does. Now kindly.
It does, then there ends the matter. We have.
No, my lord.
The High Court judge.
No, my lord. Therefore,
We did not clarify anything further. If
Yes,
the High Court
yes.
is just clear on that aspect.
Just
so
bear-
free then.
just bear with me.
This amounts to review.
So there are 3 three categories, as I said,
That we've seen.
are in the High Court. When the
Three
matter,
categories which don't need to refund the salaries.
that's what the High Court said. Your lordships have said that all the tainted, lordship's words are tainted, not category 1 to 3. The tainted ones will lose their jobs and refund. Question is, once the Supreme Court has affirmed the High Court without any variation, would it mean those three or will it mean beyond those three? I want the lordship to see that.
No.
entertain question on
that.
Because my salary has been stopped now. I was teaching on the ground that you are a part of those three.
Don't know what it is.
Lord, with great respect, Lord, these are affecting Lord life and liberty of lot of people.
We are not going to.
No, the court had give the
Lord, the lordships have already said on 17th April that people can carry on till a new recruitment.
End of the year is perhaps what we said.
Yes. No, I'm not even allowed to carry on till
Let me pick up with the authorities there.
Not the authorities.
If you are, we have only said the untainted candidates will continue, not all of you.
No,
That's what you're actually.
Right.
Point my lord to the order, it actually says something completely different.
Yeah, just see
The order permitting the continue.
Correct.
That specifically says candidates are not tainted.
Paper book number 56.
People who wish to get confused will always find room for confusion. It is not the commission which is before us. It is not the CBI which is before us.
Absolutely.
Where is the question? You candidates have various as we said, all of you asserted that we are not tainted candidates. So you come up with an application saying who is tainted.
My lords,
How-
today we have no option but to be here accepting this order for the purposes of this application. My lords, may just see that order, it doesn't say updated.
Which page is that? The 17th. 17th April.
Dubious method to get the order reviewed.
My lords have it?
17th April order.
Is not found to be.
My lords, my friend will have a chance. We are inclined to accept the prayer made in the present application insofar as it relates to assistant teachers for classes 9 and 10, that's me, and 11 and 12, which is Mr. Rohde, not found to be tainted. Not found to be tainted. This is distinct, my lord.
And they have been found to be tainted.
I have admitted that my lords find me tainted. There is no dispute about that.
Sorry. We find no reason.
My lords, my lords had said that let the SSC consider.
Clarify. We are not going to say anything. We clarify the judgment dated 3/4/2025, passed by this court in civil appeal numbers 4819-4820 of 2025 and connection matters. The miscellaneous applications are accordingly dismissed. Both 58 and 59.
My lords, of course, the SSC then will go by my lord's order.
Not say anything. Let us see.
But then that's up to the SSC, my lords.
That is what.
Some physical appearance may be allowed to be taken.
Grateful.
Master may be direct. Wait your best.
Item number 16.
Fair enough.
60.
Look, the High Court in 482 bullets, lordships have time and again said bullets. The High Court has put up the premise that it's a civil dispute.
Notice is issued.
No, but they've
your counterpart asked for time perhaps.
Bullets, they have stayed the proceedings. Your lordships have
can always be unstayed once you make your point before the High Court.
Your lordships have always held bullets and bullets.
Why should we interfere against a notice and stay order?
Look, the stay on the face of it, he says it's a civil dispute.
So, what is the date of the order?
Looks, this is 13th of
November 2024. That's 70 days delay in filing and then
7 months.
We find
70 days
delay condone. We
The
find
last one.
Then let me permit you to withdraw. I'll approach, I'll seek vacation of the statement.
Don't say that. When counsel for the petitioner, when it's senior counsel appearing for the petitioner, having argued for some time, seeks permission to withdraw the special leave petition. Permission granted, the special leave petition is withdrawn, leaving it open to the petitioner to pursue his remedies before the High Court.
Lordship, please.
63.
Sorry, I was not aware. I was called up. But I did not should not want.
In any event, your application as framed is now infructuous because that bench is no longer
No,
there.
but what happens? There is a
Where is that application?
There is an administrative order passed by the order to the Chief Justice, I am told, assigning the matter to this bench.
Exactly.
What I'm told.
Not this bench, to the other bench.
No, to this bench.
No,
No, please see, but there is an order on.
I was a party to that order.
I know, my lord, I know.
And we sent it to Justice Pardiwala's bench.
No, but then thereafter, my lord, what happened? My lord, if the lordship could just.
There was no order.
The order passed.
You keep filing application after application.
No, the same application I filed, 13th of May.
How do you do this bench hunting?
No, I'm not, my lord, on the contrary, my lord, this is.
And the statement which you made in this application completely.
Not even a word, my lord, is untrue or incorrect.
This honorable court agreed with the submission made by the counsel of the appellants that upon complying with the order, appellants would be entitled to receive. Did we say this?
No, my lord, please see what has happened.
How do you read something in our minds?
No. It is not.
On the other hand, I distinctly recall that the Chief Justice was absolutely infuriated with the conduct of the party. How do you take the possession of the premises like this?
Please see.
Immediately give it back. This is what we said.
Yes, Lord. Yes.
Not that we said that you need to be given money for indulging in these kind of actions.
There are 3 times I mentioned to the bench.
Now, enough. We've already passed an order saying that this matter will go back to that bench.
Lord, may I say this?
We have not found any order.
Hearing the larger issue, Lord, we do not know how many years this issue will get
with part of the issue here.
But Lord, I am told, Lord, if the Lordship was subject to correction.
If there was any such order, the office report would have been put up saying that the Chief Justice
Lord,
has
we have
signed.
checked up that.
There is nothing of that.
If the Lordship could just see, Lord.
On the other hand, once I was a party to the order assigning the matter to that other bench, there's no question of the Chief Justice having recalled that order without my knowledge.
No, we wanted it before, Lord, to be placed, constituted. When we filed the application.
IA number 98849 of.
Lord, may I say this?
This application is utterly misconceived and is accordingly dismissed.
Lord, may I say this? Lord, 13th of May, there is an order.
Much obliged.
Lord, relegating the matter to court 1.
Notice there on the website.
13th May, there is an order.
13th May or?
What 13th May.
That is just Pardiwala's order, because you must have said that the application is moved.
Of assigning the matter to courtroom number 1. That is what the order says, Lord.
Courtroom number 1, it will go to the other courtroom number 1.
Justice Gavai's bench, Honorable the Chief Justice. And then, Lord, I'm informed, subject to correction, Lord, that there is an administrative order passed by the Honorable the Chief Justice.
No, he only asked for this IA to be listed.
Yes, IA.
And this IA can't go to courtroom number, courtroom number 1, because I was there, not the bench which is now in courtroom number 1.
For the reasons, Lord, I leave it to the court. Lord.
Well, you seem to have asked for it.
No, yes,
Specifically, record
had said so because Lord, we wanted this matter to be heard by the.
And this was on the day that the Chief Justice was retiring.
No, Lord, what happens? Lord,
what reason did you ask for it to go back to courtroom number 1 then?
We filed, Lord, we informed the bench that this is the prayer. We took out the application prior to.
Well, the registry also understood it correctly that it need not go to that courtroom number 1, it needs to come to me. Because I was there in that bench.
Absolutely no, but as a matter of
this IA is completely misconceived.
Look, the request made is
the
lordship of the party.
And is accordingly dismissed. Registry shall list the matter in terms of the earlier order dated
9th April 2025.
4/2025.
Lord, what happened?
Much obliged.
This will be tagged along with Lord, another issue which is pending with which I have nothing to do with it. Lordship.
Please 65.
Lords, the suit was filed, my lords, on the basis that they were in possession of the property. The sale deed of their sale deed of 2005. I am a bona fide purchaser from 1998 on the property in possession since 1998 till today. Lords, it was on the
this order which was passed on 31/12/1997 by the collector, by the commissioner. That is it in finality. You never challenged that.
That's in my favor.
That is not in your favor.
That's in my favor because it releases the land from being a surplus land. I had purchased it in 1998 after that. That's why, Lord, the time when I purchased the land, there was no cloud of doubt about the title. So without challenging the title, a suit for an injunction is filed, a permanent injunction in which a title has been collaterally said it is deemed to be having title.
Now all three courts have held against.
That's why I'm here.
Where is the question?
With respect, a suit for a prohibitory injunction
is filed on the basis, I showed the plaintiff, that they are in possession. The trial court records the finding that the spot inspection which says they have not been in possession. Admittedly, from 1998 on a bona fide purchase, on a title deed, I am in possession of the property since then. The suit was not maintained in the manner in which it's framed. That's my contention. A second appeal point under section 100.
So this is Punjab Haryana.
Punjab Haryana.
Punjab Haryana.
They don't have to frame
substantial.
They don't have to. Your Lordship, there's a judgment which says that even if they don't have to, substantially you have to satisfy the test of a section 100 point. Lords, there's a judgment to that. I'll express that. But I'm on the suit. This look at the suit. It's filed. I'm not saying
lost before all the four others.
But then the suit was filed as if they're in possession. The finding is against them that they've never been in possession, and they could not have been in possession. My lords. The title is of 2000. Sorry, no, great respect. There's an equity point here. It was the retired.
No. SLP dismissed.
May I place an equity point? That's one equity point.
No, we are not.
From 1998, a retired army
filed an application before the High Court.
Lords, not going. Then Lords, just say we withdraw.
You don't say.
Lords, my title.
File an application there. You don't need our permission to do that.
No, Lords, I'm on a different.
Regarding delivery of possession.
Bear with me for a moment. Bear with me for a moment. I'm on an equity point, Lords. He was a retired.
We have seen how these equitable orders passed by this court lead to all kinds of abuse and contempt cases, and we need to undertake a fresh exercise all over again.
I'm on a very. I'll place the equity point, Lords. If the Lordship are not satisfied,
with regard to delivery of possession.
No, Lords.
Then what?
In 1998, the land was released, Lords. It was not a surplus land. I purchased the bona fide.
This 78 canals was a surplus.
Was a surplus deed. It was released, my lords. I am a retired army personnel. I went back to my village. My entire savings, my lords, 9 lakhs I have invested in that. It was released from a 426 canals at 78, my lords. From the purchaser of what is defendant number 6. The lordship will issue limited notice to a mediation on this point. Why? Because, my lords,
we are not.
The subsequent allotee is only 28 canals, part of the land, lords. I have paid 9 lakhs for this on a valid sale deed. So it's a retired army officer, not a solicitor. Well, will just permit me to withdraw with liberty to appropriate proceedings, not because my title is still valid.
Then comes for the petitioner having argued for some time, seeks permission to withdraw his petition, reserving liberty to the petitioners to invoke such remedies as may be available to them in accordance with the permission granted. The special petition is dismissed with the liberty of hospital. We, however, make it clear that we have not made any comment in that regard.
Very great. Very good.
So, Mr. Dr. Muralidhar, now that you mentioned, was this that matter before Surikant which was going on in a connected matter?
Yeah, no, apparently, well, it's this India record, the film private limited, they wanted to inflict themselves. That was refused by the High Court against
state proceeding.
Yes, yes.
No.
That's why I don't have otherwise.
No, that's why I asked you to get in the same stream.
Let's pray for a bench in which one of us.
That Punjabi video.
Exactly. Yes. Gurbani. Events.
We won't give you a date because you don't know when it will come up.
Well, the matter is coming up on 9th July. So can I request for third week of
It's all interlocutory orders.
Third week of June.
This matter
Yes.
This matter stays granted by the division bench on the ground that Order 39 to a jurisdiction has been exceeded. Whatever it is you need to say, you will need to go back to the division bench and say it along.
I am only agreeing by the observations made and the entire judgment given.
We are not hearing it. So,
Dr. Bida, I can't.
Like.
Well, may I just make one request in 1966? I appear for respondent number 3. I have instructions. My physical appearance is.
Which I?
66, my lord.
66.
Respondent number 3, I have instructions to appear. My physical appearance.
Date. Some date in July, lordship give me.
We can't give you a date now. Expeditious, please. It's the matter expeditious. 67 will take up after 68. 68.
Since it's coming up after notice is issued on the cancellation.
68. No.
But I'm appearing to respond to this. But I may have to file a counter because I have some explaining to do.
No, but not even allowing visitation, right? You have taken the children abroad.
That's the next submission.
Not fair to a father.
He says that he's not seen the children since June 24. That's
not fair.
But therefore,
so yesterday they can't.
to make one further submission. While
The person who had appeared yesterday, we do not see him here today.
Mr.
He said that one of the children is coming back.
In fact, I was not aware.
The other child is already over 18.
Yes.
He is not coming.
The daughter is over 18. But the son who's studying in Singapore now, he's traveling to meet the sister, and on his way back, he will be in India. He'll be here in the first week of July. What we would do, my lord, is before we file the counter and the matter comes to us.
You take it up, Mr. Ranjan. Yes, sure.
Yes. In fact, my lord, even before knowing that they had made that offer yesterday, I had told my lord, my instructing counsel that in July, when the child comes, let us first show our bona fides, let the father have some visitation rights, let the father do it. We'll come back and
No, did them permit a video or something?
No, video, my lord, we have been giving him links.
That was what was stated yesterday. The video links are being.
The video links will also continue to be given to him so that he can have that interaction with the child.
You're not able to access the child at least online.
My lords, let me submit. In fact, the averment made that there has been a video visitation is a totally false averment. First of all, my lord, for the last.
Have they been giving you links, video links?
No links.
Not at all. No links were given to you.
No links. No, in fact, I want to submit that.
How are they communicated, these video links?
12th July. So
how do they communicate them?
Through the council, my lord. It was in.
Where is Mr. Ashutosh Dubey? He's on record for you.
Yes, my lord, he has a personal difficulty because of which he is in Calcutta. His father is hospitalized. However, I've spoken to him. No links have been received either by Mr. Dubey or by myself.
But in fact, one side.
In fact, my lord.
Got misstatement. The communication between the parties, my lord, I noticed has only been through the council.
Anyway, going forward, at least.
So what I will do, my lord, is apart from the child coming in July, in terms of the order, in the interregnum also.
What about the daughter?
Daughter, my lord, also video links. If the daughter is willing to join, my lord, we'll give video links. I'll have to take instructions.
Where is she?
My lord, she is studying in UK because, my lord, she is joined after her 12th exam. She wrote.
And where is the mother?
The mother, my lord, is a resident of Singapore. The child is now studying. The boy is studying in Singapore.
What I intend to submit is that the respondents have chosen to modify an order of this honorable court without any information of myself or.
But your settlement also speaks about depending on the education, something is stated to that.
December 23, one arrangement.
And then thereafter, depending on their education.
And that order.
So now, as for their education, one is in UK, one is she's still studying or working now?
No, she's studying.
But you should have worked out a modification.
No, but at least you could have started together.
Come to court or between you worked out a modification.
That order could not have been modified.
Because the agreement also speaks of their own, depending on what the education
issue.
That is correct.
And Milords, not only that.
You don't take him into confidence and straight away decide.
That's true. That's true, Milords.
Milord, in fact, Milord,
that is perhaps a little high-handed on.
It is, Milord, in fact, Milord, this is really indefensible on that point. It was my view, which I was instructing the client also, that you should have intimated the court before you did it. The least we could have done is, at least after the child moved, should have come before the court, filed an application, candidly stated this and asked for modification of this visitation rights. But what we will do is, as I said, Milord, we have some explanation to do. Milord, this is not an easy case for me. I'll try to file a counter on behalf of the first respondent. Will not read it adversarial. What I would do, Milord, is Losses will record a statement that through council we will send communication links in the meantime. And 1st July, when the child comes here, the father should get visitation rights.
And also try to arrange the video links for him to speak to the daughter also.
Yes, I'll do that.
How old is the son now?
The son is 12.
12 and his daughter is 18.
Daughter is 18. But for both, yes, like it was being done earlier through council, through the Dubai council. Links will be sent, so there would be no communication gap.
But earlier also that was how it was being done. Yes. Mr. Dubey says that he never received them.
No, it happened, that July 2024 after the children moved, because it's every second Saturday and Sunday, a video link was sent. I'm told.
That's totally a false averment.
I'm basing my instructions. I was told that my list of dates has it, and the council will be
if you go into that, you
do council.
No, how was it communicated to Mr. Dubey?
From council to council.
How?
What's
by way of written letter or
WhatsApp message?
WhatsApp message.
WhatsApp messages.
And do you have the right number though?
It is. There's been communications on the same number. But what happened, as I realized, is after 12 July, when they did not join the Zoom link, I don't find any communication thereafter every month.
12 July of last year.
Last year, immediately after the children.
June, he did not see the children. After that,
June, the children moved. abroad. July, one link was sent on WhatsApp. Father did not join that link. From August, they did not do it.
Bother to send the links also.
No, links were not. But therefore, we have to bring back that in the interim and show my lord our bona fides by allowing visitation rights in July, and your lordships could work out any workable arrangement thereafter. Only one fact. My lord, the wife is respondent number 1. The in-laws and the sister-in-law are made as respondents 2 to 4. Today, I am not asking for any relief. I'll come back with an application for deleting those parts.
We have anyway dispensed with the personal, that's in the same order, if you see.
Yes, but there are a few submissions if you allot me permit I will make. Yes, first of all, the first visitation started from December 2020.
The past you leave it.
No, after
now we will make some arrangements so that you get to see your son in July, and before that itself you get to at least see them online, both your son and your daughter.
No, I have a difficulty there. I have filed certain documents. Earlier also, there were for 2 years, there were virtual visitations which were totally defeated by the respondents. And in fact, the mother was not in India. It was defeated by the sister of the mother who was there in India and the father, because they were taking care of the children. Children were residing with them. And every Sunday and Saturday, there used to be a virtual visitation. During the virtual visitation, an iPad or a book or a gaming console.
You don't live in Delhi?
I live in Delhi.
Why a virtual visitation? They're also here?
That was COVID time, my lords. Thereafter, it was converted to physical visitation. In the physical visitation, my lords, there are observations of the family court as well as the Delhi High Court. If the child has not been brought to the court or the child is being tutored against the father, my lord, all the child is being tutored against the father. You know, they have not allowed me to present the factual conspectus of the case. In fact, the conduct of the parties that brings out the intention of the parties in preventing me and my son, earlier my daughter, from completely meeting each other. For the last 1 year, it has totally harmed my relationship with my son because I don't know where he is, what he is doing. In fact, my relationship with my son was beginning to get rekindled. And that's when, out of 38 total scheduled visitations, only 5 have been allotted. Physical visitations after this settlement was. 38, 5 out of 3. Thereafter, they've taken the son out of India's jurisdiction.
To each of these contentions, my lord, we have an answer.
I don't know, ultimately, you know who is being psychologically harmed.
Parents don't realize that, but this kind of bickering between them, the impact that it has on the child.
You know, this is
and
not
then this kind of prejudicing one parent, you know, prejudicing the child against the parent.
Identical allegations.
That might in fact turn out to be counterproductive once the child attains the age of maturity.
But all the past allegations, my lord, but all the past allegations that are now being stated, my lord, by my friend who's appearing party in person. A contempt case was filed before this Honorable Court. 2nd August 23, this Honorable Court dismissed that contempt case. But today I'm answerable.
That was August 23.
I agree.
It is noticed in the order. Well within the December 23 deadline. The difference,
I'm agreeing.
Why we interfered,
yes,
notwithstanding the registrar's order was, this is a cause of action post December 23.
But I completely accept. I'm saying what my lord, my friend appearing mentioned about the past, including COVID period, all those allegations were a part of that earlier contempt. I'm answerable to your lordships. Your lordships have put me on notice with regard to my conduct after 2nd August, especially after June when the child has gone off. I need to file a reply. I need to settle.
Now, tell us what kind of visitation are you going to offer when the child comes in July? We need to know what exactly. Is he going to be allowed to take the child out?
Yes. But he can take, I think the earlier visitation right said that he can take the child between 10 a.m. and 5 p.m. He can continue to do that. The child is going to be here for one full week. Lordships could consider granting him 3 days visitation rights out of that 1 week because he may want to spend time with his friends and his other relatives here. Of 3 days or 4 days, your lordships.
That's okay with me. My only submission is, I'm only asking 2 days in a month. That was there.
The child is now in Singapore. Where is the question of you getting 2 days in a month unless you're planning to go to Singapore? And Singapore schools, I don't think they allow you to access the children like that.
In fact, I'm a government servant. I'll have to take permission from the department.
We'll also
avail this week.
This July visitation you first avail.
Yes.
Online visitation.
Also maybe
over the weekend.
Calendar of the holidays.
Make it conducive.
Yes.
After having.
But in fact, today I'm stepping in for Mr. Luthra because he had a difficulty after 2:15. He was a large part of the settlement that was worked out. He, in fact, has spoken to the clients. and today a lot of request it need to be there because serious matter he was not able.
So you and Luthra both be there.
Yes, sir.
Can we also arrange a visitation during June month because I've not met my son.
No, he's coming in July.
Singapore schedule you have to see, follow that. Now,
What we'll do is with my
you work your leave arrangement accordingly.
the travel itinerary as soon as it is finalized with regard to coming to India, that will also be shared with the council.
You don't have a definite date as to when.
Why don't you take his contact also? And why don't you take his contact and mail
me also?
Inform him about it.
I'll request my lord, my
Incidentally, I learned from
Petitioner, yes.
I learned that Singapore has
States
a
that
full
is
vacation
when it comes to
June as well as
position to attend the hearing,
He's not coming.
as he is out of station. Mr. S. Niranjan Nitin and Senior Counsel appearing for the respondents state admits that the petitioner has not had any sort of visitation after July 2020.
Yes.
Or full stop. He, however, undertakes to ensure. We take it, put it on you.
Lordship may say that I've taken instructions and
He,
Lordship may
however, states on instructions that the petitioner would be allowed to have visitation rights insofar as the son is concerned, as he would be returning to India on 1/7/2025. Full stop. He further states that the son would be in India for a period of 1 week and the petitioner would be allowed to exercise his visitation rights from 10 a.m. to 5 p.m. on 3 or 4 days as the child may choose and opt for, depending on whether you're able to build that bond with your son. We can't force him.
Well, that's true, but the time when the bond was beginning to
Very well. Now you try to rebuild that bond. So the first day, again, same thing. Do not poison him against the mother. This kind of thing that's
something I totally,
totally.
That's something that is totally abhorrent and never done.
So you're saying that they try to tutor him against you. So don't reply in the same coin.
Correct.
So as the child may
choose and opt for.
One senior counsel also states that the daughter, who is over 18 years of age, is presently studying in the UK and would be available for visitation online. Similarly, the son would also be able to join online for such visitation during weekends in the month of June.
Yes.
The video links for such visitation, for exercise of such visitation rights online, shall be provided to the counsel for the petitioner and also the petitioner himself through mobile phone. You can send the SMS also.
Yes, yes.
Better use WhatsApp. The blue ticks will also take.
Only two final
Screenshots also.
Two final submissions will not permit. It is the
We will take it up in July after the court.
My only submission is, my lord, the virtual visitation should not become a default visitation, which becomes actually an order which has a stamp of approval of this honorable court. Because this is by virtue of creating a status quo, and they are actually now.
Only till July. What else is there any other way you can visit?
It can only be an online, and in any event, the child is in boarding school or with the mother?
With the mother.
With the mother.
Yes. And the second submission is, my lord, a custodial parent has an equal responsibility to ensure that the non-custodial parent and the child share a relationship with each other. Rather, a custodial parent has a responsibility to ensure that the child shares a happy and a healthy relationship with the non-custodial parent. And I think in this case, that responsibility
that you'll have to test when you meet your son and you talk to your daughter online.
Not so far, they have conveniently washed it off and said, what can I do? The child is not.
Now, let us see how it goes. We'll take it up in July. Let's talk. July.
Great. I think the appearance slip was not given because I have made the statement with the lordship's permit us to give the physical affidavit. That name comes first. Please, your lordships. We'll place the affidavit first.
Yeah. You file the affidavit or giving?
Yeah, got it. But all that we can now do is, I'm ready to share the affidavit without the annexures. And we'll be reading not 6 important pages from the ED report, which I otherwise share the affidavit for my friend's convenience. I don't want to keep him playing the dark. I want to share the annexures.
You've given them the edited version of the affidavit.
We just got except the
much thinner than this.
No, that is only annexures. The content is the same. But 6 pages from the ED report, I have not extracted, which I'll be reading it. May I be permitted to go through the affidavit? Straight away, I'll read the affidavit. Please come to paragraph 3.
Paragraph 3.
Yes. Yes. The following facts may be taken on record in arriving at a prima facie view of fraud and collusion between the erstwhile senior management of the petitioner and the respondent. The structure of the whole case has to be divided into 3 phases. Period between 7/3/2007, date of execution of the long-term agreement, and 4/3/2010, date of the invocation of the arbitration. B. 24/9/2012, commencement of the arbitration till 17/12/2020, when this Honorable Court set aside the judgment dated 2/3/2020, the division bench of the Delhi High Court, and reinstated the award dated 12/5/2014. Period between 24/2/2021 to 16/5/2025 being the list of dates pertaining to the discovery of fraud and the proceedings emanating in this regard. Between period 7/3/2007, date of the execution of the long-term agreement, and 4/3/2010, date of invocation of agreement, agreement for sale and purchase of coking coal was entered on 7/3/2007, initially for a period of 3 years, and extendable to an addendum agreement by 2 years. But please mark this first point, at the option of the petitioners. It's our right. Clause 1 of paragraph 1, dealing with price fixation, obligates that the prices shall be mutually discussed and settled prior to the commencement of the relevant delivery period at the same price as is settled between sale and RINL, applicable to the relevant delivery period under their respective long-term agreements. That is point number 2. My lord, yesterday they showed this court's judgment, para after para, saying that you have to follow. 6 pages of the ED report says, for the same period, for the same sale price and RINL price, what they have done contractually and what they did not. 6 pages. I'm going to read that. I'm not exactly
check up the price SAL and RNL paid.
Say, I'm not
post 2008 August.
Please see and what they have done. Yeah, I'm going to read 6 pages of the finding of the ED. I have not accepted here. I read it to your lordships. But see, so I say this statement with a sense of responsibility because they were yesterday pressing too hard on RNL. Say, please, what they have done. See, the price fixation for the first 4 delivery periods are as under. Please mark the prices. 4 to 5, it is $57.75 USD. 5 to 6, it is 126.75. 6 to 7, 114, and 7 to 8, 96.4 USD dollars. It never touched 300 at any point of time. Pursuant to the fixation of price with sale at RINL in the month of 2008, May 2008, that was fixed prior to Lehman Brothers. On 3/6/2008, it was recorded by Suresh Babu in a note that sale by RINL price has fixed a price of 300 USD per metric ton for the delivery period for 1 year. On 12/8/2008, Shri Suresh Babu, General Manager Coal&Co, MMTC, sent an email stating that MMTC was ready to sign the agreement for 2008-9 and was awaiting price and other details. On 14/8/2008, so also on behalf of Anglo, replied enclosing a draft addendum, at which point of time no contract should concluded, especially for price fixation between the parties.
On 5/9/2008, there was a global meltdown due to Lehman Brothers, and the markets plummeted all over the world. There was a worldwide collapse of the financial markets, which also led to a drastic drop in the prices of coking coal and the corresponding finished products. On June 2011-2008, Addendum number 2 was executed for the 5th delivery period, that is 17/2008 to 36/2009, for a quantity of 4.66 lakh metric tons at $300. Two important sequences of facts needs to be placed on record. Firstly, what transpired between the petitioner and the respondent as found in the preliminary inquiry report. Secondly, as to what transpired before Anglo and RINL and SAIL as found by the CBI, and how there is no pari materia treatment to the petitioners. Both these sets of facts would reveal fraud and collusion between the petitioner and the respondent, and these are brought out below in seriatim. Though addendum number 2 for the 5th delivery period was entered on 2011-2008 for 4.66 lakh metric tons at $300 per metric ton, on the very same day, Shived Prakash, the then CGM, who later became CMD, had addressed a letter to so-and-so of the respondent company, bringing out the stark reality that finished products, namely pig iron, is unable to fetch a price of even $100 FOB, and the situation is similar in the domestic market, and it is impossible to import coking coal, which is a raw material at a price which is 3 times higher than the finished goods. The letter further seeks a price reduction for the 5th delivery period of 17/2008 to 36/2009 to be settled at a price of 96.4, which was the price for the 4th delivery period, which alone shall make the plant viable to function. There was no response from the respondent to this letter. On 22/2009, Anglo published a press release echoing the same sentiments as expressed by the petitioner by letter dated 2011-2008. One sentence of it I need to read from the report. Please do not come to page 201 of the SLB. One paragraph alone needs to be referred to. Please come to note 201.
Yes. They are a trading company or a manufacturing company?
They are not. They are. This will say they have mines. They have mines according to them, and see the plight of their mines post Lehman Brothers.
No, it has a purpose, Mr. Venkatraman, because
yes,
there's a mining plan drawn up, and there's something is done in advance. That's why I asked you.
I'm deeply obliged by that question. That is why I want to draw reference to page 200. 201. Please see, having drawn the plan, this is what they are saying about their own plan. And for 3 years, 201 outlook. As a result of the global economic slowdown, the second half of 2008 saw markedly lower commodity prices, following several years of highly supportive prices. Across the industry, there has been curtailment of some high-cost operation in the markets, where prices and demands have declined significantly. For example, in nickel, platinum, iron ore, and coking coal, which is our product, while the difficult financial environment is expected to continue to impact the funding and timing of many potential new mines and expansion by both major and junior miners, thereby having the potential to further constrain future supply when economic growth returns. This is their statement on their mines. But parking here, let me go back to the affidavit now. And please see the next paragraph. I will read that. How they postponed it for 3 years. The world economy faces an unprecedented level of uncertainty, and the outlook remains poor in the near term, with expectations for continuing volatility and weakness in the commodity prices. It is against this backdrop that Anglo-American has taken a series of measures to ensure that the group's operating and cost profiles are appropriate, then its balance sheet and capital structure have sufficient flexibility through the current downturn. However, over the medium to long term, Anglo-American believes the fundamentals of its core commodities remain attractive, with significant value to be created by the group's long life, low cost growth projects, several of which are timed to enter production from 2011. So their business plan gets shifted by 3 years because of Lehman. The economic recovery of the OECD member countries and the ongoing industrialization of the world's major developing markets are expected to drive long-term demands for commodities, stimulated further by government spending programs in many major economies, including the US and China. Well, now, please come back to this affidavit at Malad page. We now saw Malad page 5, page 6, Malad, paragraph I. This is the third significant point. Considering the market realities on 5/7/2009, Anglo agreed to supply ad hoc consignment of 40,000 metric tons at 128.25 and balance 9,600 tons at 300 rupees. The PE report of the CBI by pages 6 to 11 brings out clearly the discriminatory treatment meted out to the petitioner vis-a-vis sale by RANL. When the petitioners asked for extending the same contractual treatment as done by Anglo to sale and RANL. The petitioners prayed that these 6 pages of the PE report will be permitted to be read out to this honorable court, which will bring out the fraud and collusion and how equals have been treated unequally. It further shows how respondent was accommodative to RANL and SAIL. Now, please see now page 6 of the PE report, 5 pages.
Which page?
Yes, Lord. PE report is with me. Please, is there? Is there? Yes. Yes. Lord, please come to Lord, page bottom page 6. It should be 10 or 11. Page 29. Bottom page. Bottom page 6.
29 is bottom page 6.
Bottom page 6. Bottom page 6. Lord, please come to paragraph 8. Subsequently, Anglo Coal, by letter dated 21/9/2009, giving reference to the letter dated 11/3/2009, stated that the 5th delivery period of the agreement has now finished, bringing the terms of the agreement to an end. However, today, MMTC has taken delivery of 11,966 metric tons out of the total of 466 lakh metric tons. Anglo Coal letter further stated that despite their repeated requests, MMTC has not provided any schedule for taking delivery of the remaining of 5,54,000 tonnage, other than to say that we agreed to the same arrangements between Anglo and SAIL by RANL with regard to delivery of 2008 carryover tons. Anglo Coal, by letter dated 21/9/2009, also submitted the following proposals for delivery of carryover and renewal of agreement with MMTC. MMTC to perform a total of 38% of the total contracted tonnage for the 5th delivery period on the terms and conditions, including price applicable under the agreement dated 31st March 2010. This will bring MMTC in line with the contract performance of SAIL and RANL for 2008-9 delivery period. In addition, MMTC is to perform 18.7% of the remaining carryover, a further 52,000 metric tons, by 31st March 2010 on the terms and conditions of the agreement, including price as agreed with SAIL and RANL. Anglo will enter into a new long-term agreement with MMTC on the same terms and conditions as the current long-term agreement with SAIL and RANL, including the performance of remaining carry of 4.66 tons per annum for a period of 3 years, commencing from 1st April 2010. Therefore, in summary, MMTC will take delivery of 2,25,174 tons of coal at 2008 price, terms and conditions between now and 31st March 2010, and under the new 3-year contract, perform the remainder of the carryover evenly spread over first 2 years of the contract. This proposal is made without prejudice to our rights under the agreement. It will remain open and capable of acceptance until 5 p.m. on Wednesday, 30th September 2009. However, Shri Suresh Babu, the then GM, by letter dated 25/9/2009, while conveying inability to lift 18.7 and 38% of carryover quantities, and suggested plan by Anglo to lift 2.25 lakh tons by 31/3/2020 at 2008 prices, stated that it is near to impossible as it works out to 56.7% of the carryover tonnage. He further stated that in his letter that the industry is yet to come out of the shock of recession. Lifting even 18.7 carryover tonnage implies a loss of $225 per ton coke produced. Keeping these issues in mind, we had approached Anglo Coal for a reduction in the price by a letter dated 2011-2008. Lifting another 38 implies a further increase in the loss by another $80 per metric ton. For the sake of negotiation, we hope you will not ignore the economic realities completely. The steel melting shop of NIL is under implementation and the commissioning is expected sometimes in end 2010. Economy will also come out of recession gradually. In short, we are not denying our obligation. The request is only for staggering the time frame for lifting. Please review and consider the request for allotting at least shipment of 50,000 plus or minus each from October 9 onwards instead of zero stem till end of 2009. In respect to MMTC,
what is full form of stem?
Stem it's a monthly quota, shipment quota. I'll explain. I guess they could also say, but the officer explained it over VC. Per month quota, one-time consignment of the cargo moving from Australia to India, a full shipload, what they call it, a system.
Subject to enough material.
Enough.
Subject to enough material.
That
Subject to enough.
is you notify the MMTC. You have to notify stem, is it? Yesterday you were told you notify the stem.
We nominate the vessel, we notify that there is enough material, then they ask for the quantity. Because what is decided is the annual quantity is decided, which in these cases was 466,000 metric tons, and that had to be spread over various delivery periods for annual.
In response to MMTC's letter dated 25/9/2009, Anglo Coal by letter dated 25/11/2009 addressed to HON'BLE, Director Marketing, while referring to their earlier letter dated 27th September 2009 on counter proposal MMTC by letter dated 25th made another proposal to MMTC to perform the remaining quantities of 4,54,000 metric tons of 2000 contract in line with Anglo's arrangement with SAIL and RINL at 2008 price of USD 300 to be scheduled as under, and stated that the offer is valid till 5 p.m. on 4th December 2009. January 2000 to March 2010, followed 18.75%. April 2010 to March 2011, 40.65%. And April 2011 to March 2012, 40.65%. Thereafter, Shri Suresh Babu, the then GM Koki, by letter dated 27/9/2009, addressed to Rod Elliott, Anglo Coal, referring to Anglo Coal's letter dated 25/11/2009, by which offering staggered supply of carryover quantities of coking coal pertaining to 2008 contract in line with Anglo agreement with SAIL and RINL at 2008 price of USD 300 per metric ton as per schedule, stated that the above parcel is acceptable to MMTC subject to Anglo Coal allocating the leftover quantities pertaining to the 2009 contract at 2009 prices, which is $128 rupees per 128 USD per ton, on the terms and conditions agreed upon in the EJC of SAIL and RINL. To be specific, the balance supply amounting to 4,25,000 for the Empowered Joint Committee, Anglo, SAIL and RINL. They are the three co.
This is the government of India.
This is the government of India. Anglo has nothing to do with it. Anglo follows whatever the Empowered Joint Committee decides for SNL and RNL. After that, Anglo adopts it for its delivery period. Because the contract said it will be the same as
JC consists of only two entities.
Yeah, RINL and SAIL. Yeah,
and consisting of joint secretaries, government of India, etc.
There will be a GOM in this. Group of ministers also will be there. This is taken at that level.
Okay. Secretaries from senior officers from the Ministry of Power and Steel constitute the Empowered Joint Committee, which sit and decide as far as SAIL and RNL is concerned what the price ought to be.
that $300 per metric ton.
Let me continue with the report.
The court asked a question.
Let me continue.
Court asked a question, which said,
No,
it
court
was
asked
a
MJC.
Just a minute.
Now, 1 minute. I want to read a very critical paragraph. He's interpreting my flow. This is the critical paragraph I want to say.
Yes, sir.
We've
That's-
understood what, I
that's
just
all.
wanted to know what.
Yes, that's all. That's all, and that's what we follow.
Obligation. Lord, please come to this. To be specific, the balance supplies amounting to 4,25,600 metric ton at 2,000 price level of USD 128 or 125 per metric ton shall also be made in proportion along with the carryover quantities of 2008 as proposed above, in line with the terms agreed with SAIL and RINL. So, you have a 300 USD for 2008, you have 128 USD for 2009. That is the agreement. Whereas what was shared in the previous column is only the 2008 staggered supply without accommodating the 2009 adjustment for carry forward. So we only said, please extend parity. Please, Lord, one last time I'll read this sentence alone. To be specific, the balance supplies amounting to 4,25,600 metric tons at 2009 price level. So only 30,000 tons should be taken at $300 US. At US price at 128 and 125 per metric ton shall also be made in proportion along with carryover quantities of 2008 as proposed above, in line with the terms agreed upon with SAIL and RINL. In response, Mr. So-and-so, by letter dated 1/12/2009, informed it is not possible to make any additional tonnage commitment to MMTC over and above the detail in the proposal of 25/11/2009 and recommended to accept as a pragmatic approach that restores the working relationship between the organization. The proposal was open and capable to acceptance till 5 p.m. on 4th December 2009. In the meantime, the 163rd meeting of the SPCOD held on 2nd December for finalizing long-term agreement for import of hard and soft coal for NIL and price material of hard and soft coal for another 2019 as per agenda dated 10/11/2009 of coal division. The committee was informed of the division that the consent of NIL has since been received. However, supplier desires that the quantities under the previous contract be lifted before the quantities under the fresh agreement supplied. The SPC would, according to Director Hanman so-and-so, should take up the matter with the overseas supplier for ensuring that the quantities in the previous contract and under the new contract are supplied with the suppliers in the ratio as has been agreed by them with SAIL. Subsequently, so-and-so Director Marketing, by letter dated 3/12/2009, addressed to Anglo once again review their stand and give the same treatment to MMTC at par with SAIL and RINL as agreed in EJC. He further placed emphasis that MMTC is buying coal for NINL, which is producing pig iron only, and the same is not an integral steel plant like SAIL and RINL. He further stated, at current prices of 128.25 metric ton, MMTC is finding it difficult to run the factory and are incurring losses subsequent to economic meltdown, and it is difficult to survive. Under these premises, MAN requested Anglo to once again review their stand and give the same treatment to MMTC at par with SAIL and RINL as agreed in EJC. Further, it was stated that MMTC is looking for Anglo's cooperation so that somehow it can run the plant by having a mixed price coal. The MMTC, by letter dated 3/12/2009, once again repeated the commercial difficulties it would face should it be asked to perform the agreement and requested Anglo Coal to review it. Stated Anglo Coal, by letter dated 7/12/2009, responded and reiterated that it is So, Bullard, I'm reading now Bullard internal page 9. Subsequently, MON director by letter dated, I'm saying, I'm reading paragraph 14. Anglo by letter dated 7/12/2009 responded, my lord, and reiterated that it is not possible to make any additional tonnage commitment on MMTC over and above the detailed proposal in 25/11/2009 and stated it has given every consideration of related issues and proposed an alignment with the arrangement to the SNL to maximum extent and informed that the offer is open up to 7/12/2009. Subsequently, so and so the CGM code submitted a proposal note dated 21/12/2009 for seeking approval of SPCOD for import of coking coal for NINL settlement or finalization of the price per agreement which supplies for the year 2009-10, which was considered by SP1 1168. I'm reading paragraph 8.
What is this SPCOD?
Sale Purchase Committee of Directors. Sale Purchase Committee of Directors.
Of directors.
Of directors.
Of the company.
Of MMTs.
MMTs.
The SPCOD, upon examination, approved the proposal subject to the ratio between the quantities against 2008-9 contract and quantities against 2009 contract to be at the ratios agreed by the overseas supplier with SAE. The position submitted by, say, SPOD with respect to Anglo supplies for such decision by SPOD is indicated in the table below. Anglo confirmed allocation of 2008-9 carry forward tonnages in line with sale. For the present, due to dead dog, no quantity has been proposed by the division. Consequently, in order to resolve the issue, senior representatives of MMTC met the representative Anglo Coal at Brisbane, Australia on 5/2/2010. During this meeting, MMTC proposed a fresh agreement with Anglo on lines which it has entered with SAIL and RANL as a precondition for MMTC to perform its obligation under the agreement dated 73 and its addendum so and so. However, Anglo Coal turned down the sale. On 4th March 2010, so and so solicitor, letter dated 4/3/2010, served a legal notice to MON Director MMTC on behalf of their clients Anglo Coal for breach of its obligations under the agreement dated 7/3/2007 for not lifting 454,000 metric tons of coking coal. Accordingly, MMTC was held liable for all costs and consequences of such non-performance and raised a demand of a compensatory damage from MMTC, the sum of USD 78, 7,200 and etc., along with an interest 12% per annum from 30/9/2009 till the date of payment. It was further informed that if the demand is not satisfied within 1 month of the receipt of the notice, his client so-and-so shall initiate appropriate legal proceedings, including arbitration proceedings as may be advised in accordance with law. Subsequently, after a gap of 2 years, so-and-so, by letter dated 27 June 2012, addressed to Ved Prakash, then Director Marketing, citing some commercial differences which interrupted supplies for some time, again approached MMTC proposing for resumption of supplies afresh of coal during the current delivery period ending on 31/3/2000 on the same terms as per SAIL and RANL. So-and-so also confirmed their supplies to MMTC and also assured that the old commercial dispute will be closed and mutually settled amicably. MMTC did not respond to such offer. However, Ved Prakash within that means reference to so-and-so then process with who in turn the same to Anita Garg, the CTGM, stating please examine put up, but no action appears to have been taken by the division. Consequently, so-and-so had letter dated 24/9/2012 invoked arbitration clause in the agreement and furnished the statement of claim which led to the commencement of arbitration proceeding. I'll stop here now. But please, this 6 pages, my lord, what is their case before this court which they showed yesterday to succeed? This court has approved in terms of clause 2. This court has said go by RNL and SL. This court has endorsed that your pricing mechanism is tagged with it.
You must have raised this issue during
I put it this way. I got what this was not all this is KBS.
No, not this report. The issue that they had settled with SAIL and RNL at a different price. These issues were raised?
But no.
During the course of the
yes, instruction. I'll tell you why. Give me just 3 minutes. Now the whole story will unfold. How this is a subtle fraud in most sophisticated, one of the most sophisticated corporate fraud. You have both sides on the same sides. You'll have to only create documents for 3 years. You will say, I want to match. They will say, we will not match. They will say, I will give you this. You will say, I will not take this. And after 2 years, you will say, can we renegotiate? After the all period is over, you will try to match. And say, no, I will not agree. And then institute an arbitration. One single ton has not been received. It's not that they brought all the consignments to India and they were all waiting in the harbor, weathering all the conditions, and then the coal conditions. No, not a single gram of coal came. 4.54.
Nothing came. was a repudiation.
Well,
It was sued for damages.
Therefore, this, well, in the whole
Suit was for not lifting.
well, please, well, what I'm trying to say, the contract and pollution is so beautifully designed. No loss for them. You don't have to lift.
What you must show, Mr. Vikraman, is something about brothers. The 300, when it was fixed on August or September 2008,
November,
that was fraudulent. Because thereafter, what has happened is they say, you kindly stagger it. They say we'll stagger the quantity 17, 40, 40 up to 2011. They say, no, can you do the latter part at 2009 prices? They say, no, we won't do. And then there was no lifting of 40,000.
Two things have happened. May I put it this way? If I can, I don't mind reading it one again, but I can summarize what this is.
The difference between outgo having happened with coal having come in at an exorbitant price, as opposed to a breach resulting in a suit for claim for damages.
May I put it this way?
Hotly contested thereafter.
No, but I allow me, but if you can see apparent is real, that's definitely one view to take. I don't deny. Apparent is not real is what we are now trying to unmask and put it to your lordship. Why? Lord, you have three parties: SAIL, RANL, and MMTC. Two of them are in the EJC. And they have agreed on $300 in June 2008 prior to layman. Or in terms of 2.2, post layman, we also agreed. Let's travel that far. That 11 o'clock, the agreement is signed. 4 o'clock, a letter is sent, we can't honor this price. Same. See, Lord, you have to see, Lord, in a corporate fraud, it can't be as white or as black. It will always be black and white in a corporate fraud. You will have a banking transaction, you will have proper mails, you will have everything on record, my lord. It will show everything is done in a commercial way. That's how a corporate fraud happens all over the world. So how they have dressed it up so beautifully. So morning you will sign a contract, evening you will write first starting point, my lord, that this is not the agreeable price, because what are they saying in that letter? My finished goods is costing only $100 today in the market. I can't import it 3 times more. And first point of deviation. This is the 4th period and 5th period, not the first 3 period, which is mandatory. 4th and 5th is your call. Call of MMTC to decide and ink an agreement. They could have simply said, I don't want this agreement. Who are the colluding parties? Managing director, general manager. All the 4 put together are the one who signed it, who managed all this correspondence for 3 years, and who ran the arbitration for 8 years. Till the man retired in 2020. Immediately, I'll put the list of dates. Immediately, the new managing director.
The same question. Everything that you're saying puts your people in the dock. Where is the publicity on their part?
I'll put it this way. Step 1. When you had a chance to get out, you chose to write. All right? You chose to immediately flag it on the same time. All right? 3 times, my lord, 3 exchanges of correspondence say, look here, 3 times, not once. You have not only staggered quantity for RANL and SAIL, you staggered it in such a way, 4.54 lakh metric tons of their import will be at $128.
Why?
May complete 2 minutes. So, for me, 4.54.
Where do you get that?
Yes, please see that. That is exactly the point. Lord, please come to internal page 8. That is precisely the problem here. It is not just staggering the quantity. By staggering the quantity to the deferred period, the deferred price has been triggered for RANL, but not for me. Once you get into the 2009 block, the agreed price for the 5th contracting period is 128 and 125 per metric ton. May I read it, my lord? Please come to, Lord. I'll come to page 7 for a minute, because this is the triggering point. These 3 pages are very, very critical.
You read it, but keep one thing in mind.
Yes,
just as a doubt, you may answer it. 2 people want to take some money out of the country, India, treasury. So the idea is come to an exorbitant price and take the money out. Now the money was not taken out. You are saying the invitation to litigate in a hotly contested litigation with the uncertainty of a arbitrator award is the ultimate promise in a conspiracy.
Lord, if I can say this with reasonable response.
What happens in a conspiracy? They pay the price,
Lord,
they take the coal, take inferior coal, release the price, money is gone, booty is shared. You are saying all that happened was 300 was fixed and then negotiations happened for, reducing it, etc., by the same person. And at the end of it, they get an award. How many years? 8 years.
8 years.
And now we are today in 2025.
May I explain this? I say this with a sense of responsibility. Having now been
assuming all this can be gone into
I say it can be gone into because it's fraud. Because it is fraud. But which forum will I go for?
Unlike the other scams which have been going on, some are in subjudice, we don't want to comment. You see, anybody who conspires.
So, can I explain it? Your Lordship put a very relevant question, I'll explain it. Lord, this is an occasion, a court is rising up, how this is happening. It's an occasion for us as a lot of the officer working with the government and various arbitrations. I can certainly help this court. But currently we are doing at least 8 to 9 international arbitrations, BIT and Commission. Lord, may I say this with a deep sense of responsibility? I make a statement, Lord, working that I'm making this statement. Are failed the businesses, planned the conspiracy. Arbitration is one of the surest routes across the world. Please, I make this statement with a sense of I stand by it. I will stand by it in making this statement.
BIT arbitration is offered on a
not when I say ICC commercial. I say BIT. One is BIT with Republic of India. Another is commercial where PSUs.
More on the system, including the judicial system.
I'm talking of ICC involving PSUs. I'm saying this 9 arbitration involving both BIT and ICC. We are all involved. I'm pitched in this. And I'm saying this with a sense of what we are fighting today. Currently, we are fighting a case in Netherlands and Mauritius Supreme Court, where the Lord, at the time of enforcement, they are giving us an opportunity to prove fraud. 3, Lord, lower court, district court, court of appeal, Supreme Court, confirming the award. We have moved, my Lord, at the stage of revocation, post-fraud is detected. We are moving. Matter is being heard, saying that if fraud can be, because Lord, one concept in arbitration, fraud is anti-public policy. It's contrary to public policy. And my Lord, especially when you find PSUs and governments on the other side. I'm not trying to give me an extended arm of hearing. Lord, in these articulations, the structure, the filters, they have their own complications. My lords have to bear that in mind in the structure. It is easy to say, my lord, you are like a contractor, you have signed the contract, you have to do it. That's one way, no doubt about it. There is also another way in all these articulation. In commercial disputes today, my lord, arbitration is a sure shot of taking back your investments. I say this with a sense of responsibility. Lord, may I read this now? Yes. But 3 points we wanted to convey on these 3 paragraphs very importantly. Lord, I'll read from in the bottom page 7, subclause 10. In response to MMTC's letter dated 25/9/2009, Anglo Coal, by letter dated 25/11/2009, addressed to MAN, while referring to their earlier letter dated 21st September 2009, on counter proposal of MMTC by letter dated 25/9/2009, made another proposal to MMTC to perform the remaining quantities of 4.5 lakh crore of 2008 contract, in line with Anglo's arrangement with SAIL and RINL, a 2008 price of $300 to be scheduled as under and state that the offer is valid. This is what they write. So they don't give a reduction in price, they only stagger the quantity. Now please see our response. Thereafter, see Suresh Babu, the then GM, by letter dated 27/11/2009, addressed to so-and-so, referring to Anglo's letter of 25/11/2009, while offering staggered supply of carryover quantities of coking coal pertaining to 2008 contract, in line with Anglo permit with SAIL and RL at 2008 price of $300 as per schedule, stated that the above proposal is acceptable to MMTC, subject to Anglo Coal allocating the leftover quantities pertaining to the 2009 contract at 2009 prices based on the terms and conditions agreed upon in EJC of SAIL and RINL. To be specific, the balance supplies of 4,25,600 metric tons at the 2009 price level of USD 128 and 125 per metric ton shall also be made in proportion along with the carryover quantities of 2008 as proposed above in line with the terms agreed with SAIL and RINL. They were averaging the loss and profit. In response, so and so, while letter dated 1/12/2009 informed it is not possible to make any additional tonnage commitment to MMTC over and above that detailed in the proposal on 25/11/2009 and recommended to accept as a pragmatic approach that restores the working relationship between the organization. The proposal was open and capable of acceptance. So first milestone, your lordship, is averaging. Now come to the next two pages, still worse. In the meantime, so-and-so SPD held on 2nd December for finalization of long-term agreement for import of hard and soft coking coal of NINL and price settlement of hard and soft coking coal for the year 2009-10 as per Agenda Note 1011/2009 of Coal Division. The committee was informed by the division that consent of NINL has since been received. However, supplier desires that the quantity under the previous contract be lifted before the quantities under fresh agreement are supplied. SPOD accordingly directed MUN should take up the matter with the overseas supplier for ensuring that the quantities under the previous contract and under the new contract are supplied by the suppliers in the ratio as has been agreed by them with SAIL. Second milestone. Subsequently, MUN directed addressed to so-and-so in Anglo to once again review their stand and give the same treatment to MMTC at par with SAIL and RINL as agreed in EJC. He has further emphasized the MMTC.
We have crossed the fifth cycle. This is post the fifth cycle.
No. This is two things. All of us have balanced quantities in 2008. Now, what they have agreed for RINL and SAIL and which they did not, we will average your 2008 deferred supply for those. Correct. With the 2000 supply, there will be a contract for fixed period for 2009. At the average price of 125 and 128.
That basically shows that they were able to negotiate with them. You were not able to.
No, I'm not. I will not negotiate according to them, according to this court. Whatever happens will happen to me. That's the fact. My friend is crying yesterday, showing this court at Henso. Yeah?
That is only the tagging of the price.
No,
whatever contract they have, you automatically get the same contract.
We can't peel it out like that. I don't have any individual bargain. According to them, according to Anglo, there is no
says you will buy at the price that they decided for SAIL and RINL. Price is the only thing that is tagged.
Put it this way: to say you will piggyback for price, you will not piggyback for no. See the arbitrariness in this. See the outright arbitrariness in this.
For fifth cycle, fifth delivery period.
Yes.
Is 1st July 2008 to 30th June 2009. That's the fifth delivery period. Now, we are talking in page number 8, printed page 8, page 31.
Yes.
Of EJC's agreement for SAIL and RINL, post this.
Yes. Well, for the default.
That's correct.
Yeah.
As we understand.
Correct.
The request was, now 300 is agreed now for 1/7/2008 to 36/2009. Please stagger it. They said we will stagger the lifting of quantities,
not the price.
18.75, 40.65 and 40.65. But all this you may lift up to March 2012, but at 300.
Right.
Negotiation was, please stagger it, not only the lifting,
but also
the price in which EJC negotiates with RIL and say for which period.
So same period, 2008, but the average is my balance of 2000, balance of 2009.
So post June 2006.
Yes.
How will that show what
we are going to place orders? But we have
what RIL and SAIL paid between August 2008 and June 2009?
They deferred it, my lord. What? See the advantage. Quantity is deferred. Then it averages.
They also fully deferred.
Yes. That is precisely our cry. You average it. Didn't. And not to say for price you will go, but not for. Pages of my affidavit. This is only the starting point. Well, another 16 pages I put.
Let us look at that clause once again where you tag the price.
Correct, the clause 2.2.
Well, on my turn, I just told to your lordships all the questions that your lordships are asking on this staggering. Justice Muralidhar, sitting as a judge in the 34 court, which was upheld by this court, in detail dealt with this entire issue and every correspondence upholding the award. All this business of carryover, staggering, what was mixed, all dealt with him.
Not just with them, even say.
And I'll point out the para, then I tell you not just what happened if you just give me a minute and doesn't.
No, this cannot happen.
As a matter of fact, just as a matter of fact, why did you negotiate with them and not with anyone?
Because, and I'll tell you not just why. I'll tell you not just why, and if my learned friend permits, because he gets. What happened was, their contract was naturally slightly earlier in time. This condition from 2007 is in the MOU and in the LTA that whatever you agree with SAIL and RNL will apply to MMTC also for the fifth delivery period from 2007. In May, this $300 gets negotiated for RNNL and for SAIL. And that is what is conveyed in the letter dated 14th of August 2008. Now the slump happens. In long-term contracts, what very often happens is they take care of a period spread out over a period of time. For instance, in the fourth delivery period, even the internal note that they showed, the spot premium as per their internal note in the market was $400 per metric ton and it was being sold for 96. So you take the loss, you take the profit. Reverse the situation in the fourth delivery period. It's 96 what he's shown, but his own internal note shows the spot premium was 400. So when everyone approached and Lehman Brothers had happened, and as Justice Muralidhar discusses in detail is, what was offered was that you will, in a carry-over mixing mechanism, take some from the fifth delivery period and for future delivery periods, pay at whatever prices they are negotiated. So you stagger it over 2 or 3 years, but you have to immediately do. So you get a bit of 300, you get a bit of the lower prices that were pending. This particular party, unlike SAIL and RNL, which lifted huge quantities even under the fifth delivery period, took only 11,000 metric tons in 1 year and said, no, give me the same terms as SAIL and RNL. We said, we can't. You either compete and perform on the level they are performing, you'll get the benefit. But whether I give you the benefit or not are all extra contractual requirements, whether I do it or not. Doesn't make it a fraud, doesn't make it a conspiracy, doesn't make it a criminal act. These are contractual facts. I'll show in my own turn detailed findings of Justice Muralidhar on these issues.
No court has examined it or not. Somebody has to examine it. But this is a tip of the iceberg. I have another 16 pages to read after this report. A detailed complaint. What are all the allegations of each? Everything I put it in this 24-page affidavit. Lord, may now continue further in this and then take your lordship to the balance portion of the affidavit. So, Lord, this is the whole crux of it. 3 times it goes back and forth. And Lord, this is not agreed with me. And after 2 years, an arbitration notice is issued to us. Now, Lord, please continue with my affidavit. Having read these 6 pages, please come to, let me take your lordships to my affidavit. At my lord, page 7. Moment. Court judgments on arbitration and fraud, discovery and fraud, and what this division bench of this court has said about these types of frauds. I'll read those passages. But I will read facts and supported by 6 judgments of this court. I'll read on how this, and do I have a right? I will show that I have a right to stand up and, but somebody has to examine. Lord, it's not that everything is lost. And to say that, Lord, please see the situation in the
long and short of it is you're wanting us to hold a hotly contested proceeding to be collusive.
No, what I'm saying, well, my interest is very limited.
We know between a collusive suit and a hotly contested suit.
Now, may I put it this way? My relief at the moment is what? I'm not saying anything else. Not who,
you file a review also. Thereafter, you file another application, get the interest rate reduced.
No, that's
not a question of saying that your officers were not acting in the interest of the
simple. Lord, may I put it this way? One way to look is on paper, whatever steps have to be taken has been taken on paper. But
not on paper, effectively.
The whole discovery is whether it's effective. That is the whole doubt. Lord, we will show letters. I put it also. The same Suresh Babu, while negotiating, says, we admit. Written letters, we admit our obligations are, we are a defaulter or not. He writes, he is one of the culprits in the whole, what we saw.
Again, it all boils down to your people.
But
somebody has to take a decision.
Therefore, what will take? May I only say at this moment, I'll go further, no difficulty. What are we asking today? Lord, if it's an Indian company, it's a different story. It's an Australian company, they don't have a bank account here and nor have monies in India, nor have assets in India.
Apart from this, do you have anything against them?
No, I read the rest of the evidence. We have a few more. We have a few more to say. From this side, now they've touched it.
Has Suresh Babu got assets in Australia? Has he got property there?
We find all of them to be outside India at the moment. What they have, we have not. That is
you're quite capable of collecting.
Yes, now please see, my lord. I'll show that paragraph. What is happening currently? Please come to paragraph. What is happening currently in CBI? Please come to, my lord, page 16 of our affidavit. Page 16 of our affidavit. And I read the whole thing. 16. I don't want 1/6 of our affidavit, additional affidavit. But let me be allowed to read the rest of the paragraph. But I'm just, because your lordship wanted what is CBI doing, I'll answer this.
Yes.
After the registration of the preliminary inquiry report on 9/1/2023, the officials of the CBI visited the office of MMTC for the purposes of investigation on 30/1/2023. Thereafter, the officials of MMTC have been summoned by the CBI on 9/2, 10/2, 1/3, 2/3.
How did this help?
Yesterday what we did, I tell you what, there is a CBI circular of 2015. We requested them to come to the court and bring the file. They said that we are under investigation. We need to take orders in one day. We will not be able to. So, it's not that a closure report has been given or found to be faulty or found to be very active investigation is happening for the last 2.5 years. Now, all that I'm requesting, what are we requesting today? Money is not a problem which is safe in a kitty. It is with the registry. The entire 1,100 crores is deposited with the Delhi registrar. And it is earning 7.5% interest. And 36 title deeds for 1,200 crores deposited with the registry. And they don't have a bank account. They don't have any assets in India. If this money is coughed up and gets into their credit account, and tomorrow, if I'm able to succeed somewhere, which I have a right to do, I'll show judgments, a civil suit will lie, an interim obligation will lie, everything I've got judgments. Everything I'll show to your lordships. I want to continue improving our judicial remedies available. But we can't be rendered remediless. This court several times have said, I read all those judgments, we can't be rendered without a remedy. All that we are seeing today, my lord, is let the money earn its interest there. I am not saying I will take the money or they will take the money. Let it remain there. And my lord, our suit on maintainability is already reserved by the learned single judge. Same judge has reserved it. And my lord, our application on
reserved what? The cases?
No, we have argued on maintainability because they have raised an preliminary objection on maintenance. We have argued at length. And what our application for interim stay is pending before the LPA, before the division bench. But it came today, we have taken accommodation for Tuesday, and direct judgment of the Supreme Court says, when a civil suit is pending on maintainability, if there is going to be a delay in rendering a judgment, then the court has to protect the interest of the parties to an interim order at the judgment of this court. It's not that we can't be rendered with an order to say tomorrow on Monday you can go and take with your money. And what happens after that? And today's interest is protected, They are earning a 7.5%. If it's their money, they are earning 7.5% interest. If it's our money, we are also earning 7.5% interest. Whose interest is not protected? All that we are saying, we are not asking your lordship to try it here. We are only asking for this interim arrangement to continue. Nothing more. We can't be rendered remedy-less for and such a huge amount.
May I only make one submission? I have succeeded as far as the challenge to the award is concerned. I have succeeded as far as the enforcement of the award is concerned. The objections have been dismissed. My learned friend's argument, because you choose to file a suit which is unknown to law under the Arbitration Act, to setting aside an award.
Which
if
I'm
you
sure
my
it's
learned
known to law.
friend will not interrupt. I don't think you can interrupt like this. All that I am respectfully submitting is to file a suit which you ought not to have filed. Your only remedy, if your story is correct, which it is not, is that under the underlying contract, if you have a problem with the officers or a fraud, there's an arbitration agreement. You should have invoked it in an ICC arbitration. You do not do it. You file a suit which is non-maintainable. How can today an execution and enforcement of an award, of an international award, be stayed like this? And what is his best argument? They don't have a property here, they don't have an account. So by that logic, my lords, any foreign party which comes and succeeds in an international commercial arbitration merely because it's a PSU who chooses after 15 years to file a bogus complaint with the PE with the CBI, comes and says, now don't let this go because I'll be remediless. Why remediless? You are remediless because you lost the award till the Supreme Court. You lost your case as far as the enforcement is concerned. And may I also point out to you, my lord, that is actually not really the germane issue here. Even as far as their so-called CBI PE is concerned, they went to the CBI court, direct them to register an FIR. The CBI court asked for the status report, which I am not privy to. After that, they said, I cannot direct them to register an FIR. And then they went in a revision to the High Court, which is pending. So my learned friend is effectively today saying, and that is hardly material. That's not material. I'm pointing out because repeatedly this issue is thrown at your lordships. Fraud, fraud, fraud. I show para after para of Justice Murali's judgment in this matter, which says there's a whole process how this was done. It was a price agreed to. In fact, we were the ones who were saying there is a slump in the market, which Justice Nariman dealt with in para 17 of the case. There is a slump in the market and you are not willing to pay the higher prices and you are willing to pick up. That was our case. Their counsel, who appeared at that stage in the 34 court, there's a para recorded because we had also sued for damages. If your lordships to recollect, as my lord said, it was for damages and repudiation. So we sued for damages. When we sued for damages, we said there is a slump in international markets. That is why the price between $300 and the lower price is the damage I'm entitled to. It was my case. It was not their case. Their case was no. Their counsel, and I'll read one paragraph at that stage, which appeared for them, made a statement that like us, there is another party, which is the largest producer, we are the second largest producer worldwide. They said no. We picked up from them at the same time at $292 a metric ton. That's their statement. Recorded in the paragraph before Justice Murali, because they wanted to avoid damages. And they said there was no basis for damages because it's 300 versus 292. It has never been their case that I today decided to lower the price. Where is your case pleaded?
You have been given the difference between 300 and
Lord, that was
126.
Absolutely.
Today, my learned
Two different qualities.
Just a minute.
One lakh, no.
Just a minute. Let me
1 lakh 90, 1 lakh 280. They were not taking qualities and mixing in their
all that I'm saying.
two different qualities.
In any event, the hearing has to be completed.
Yes.
Mr. Venkatraman has to be heard, good or bad.
Yes.
So we can't cut short the hearing. So we'll have to keep it pending.
Yes, it is.
So I was all the time respectfully submitting, even I can't say anything to that because I can see that your lordships are 5 minutes from freedom.
I'm there next week. Partial working.
Partial working.
I'm there
next week.
It's my lord's partial freedom. All that I'm respectfully submitting is, my lords, your lordships have heard this matter at length. I will only beseech your lordships to keep it as part of it.
Yes, we'll keep it as
because it can't be that after 4 hours of argument, we argue the matter again.
I want to agree somewhere, but I'll agree on this. I don't want to disagree.
Let's have it. Please have it.
When is the maintainability suit listed for judgment?
That's already reserved.
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 Same learned judges.
Yes.
Same.
But that's not waiting for this.
No.
When we moved the interim order in an LPA to the division bench, that division bench will inform that they said we will not pass any orders till the court decides it. So it came today, we took it to Tuesday and we'll take it further time. Their court is inclined to say till Supreme Court.
No, my lord, so make it clear that they can pronounce. Let this not be a ground to pronounce there.
So the division bench and the LPA, we can go ahead, we'll tell the court.
Arguments heard in part. Very strong.
LPA is on what?
LPA, the limited point on interim order, on against when there is a maintainability, they did not grant stay. Against that, we have gone on a limited prayer and LPA, relying on a judgment of this court. When there is a delay in passing an order in maintainability, you have to protect. Otherwise, it becomes irreversible. Which court was inclined?
24th July at 2 p.m. Registry is directed to obtain necessary orders from the Honorable the Chief Justice for the special setting of this bench on that day. We make it clear the pendency of this case shall not reach proceedings before any court from goings.
Grateful. Protection till then.
No, please do not. We will not take any precipitative action. You don't have to fight on every issue.
No, I agree. Thank you so much.